Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-7016. Zhongshan Fucheng Industrial Investment Co. Limited versus Federal Republic of Nigeria, appellants. Mr. Bradley for the appellant, Ms. Cernsevich for the appellee.
Good morning. I'm Keith Bradley, representing the Federal Republic of Nigeria. Sometimes governments have dealings with private parties, maybe to procure services or to sell assets. Sometimes those deals go south. This is not that case. Nigeria has acted throughout this matter solely as a sovereign. Our law respects the immunity of foreign sovereigns from the power of our courts, and it denies that immunity only subject to specific exceptions in the FSIA, which are to be narrowly construed. The exception claimed here is an arbitration award that is supposedly under the New York Convention. That convention is concerned with private law disputes. So says the resolution that adopted it. So was Nigeria engaged in any private law activity? No, it was not.
Was Nigeria considered as a sovereign entity to be a person?
Your Honor, in its sovereign capacity, it is not a person. It is a person only when it engages in private law activity. That is the long-standing thread in U.S. law and is certainly what everybody seems to have taken for granted during the preparation of the convention.
So what are you considering to be the sovereign activity? Is it the treaty itself and then all the investments and connections for this project? Or do you separate the two?
I think I would turn the question around, what private law activity would there be? So okay. Yes, Nigeria had a treaty that was surely sovereign, which I think Zhongshan agrees was sovereign. Nigeria itself made no investments. It was a sovereign government of a country within which Zhongshan made some investments. It is accused of having engaged in certain expropriation activities, which are police activities, for example, that are well established to be sovereign. I don't think that Zhongshan really points to anything that Nigeria did that was private law activity. Nigeria didn't transact with them. Nigeria did not make the investments itself, for example.
Nigerian police were very much involved in the what's alleged to be the violations, were found to be violations of the investment agreements that were undertaken in this case.
Your Honor, I want to break that out a little bit if I could. When you talk about the violation of the investment agreements, to the extent that Zhongshan had contracts within Nigeria, the Nigerian police did not breach those. Nigeria was not even a party to those. Nigerian police were found to be involved in the expropriation activities.
Yes.
But
which was alleged to be the violation of those agreements.
But not of the contracts, because it was not a party to contracts. And the activities of police that one might call expropriation are very solidly sovereign activity, not private law activity. So it says Saudi Arabia v. Nelson and also.
No, I understand, but it's not as though Nigeria had nothing to do with this dispute.
I mean, certainly the arbitrators found that Nigeria itself was involved in activity that they found to be expropriation. Yes. And our point is
expropriation, arrest and torture and abuse of a government, of a business official.
And I'm not here to defend the substance of that activity, but as the Supreme Court said in Nelson, however one might feel about, however one might criticize the awfulness of the activity, it is sovereign activity, not private law activity.
It's a little hard to separate out commercial activity from sovereign activity in the kind of case we have here, which is a sovereign sets up a bilateral investment treaty, which is designed precisely to induce investment activity by investors of the counter sovereign, and that happens. And when something bad happens to the investor of the counterparty, there's arbitration, and you could characterize the dispute as a breach of the relevant contracts, or you could characterize the dispute as a breach of the treaty, which provides for fair and equitable treatment, most favored nation status, no expropriation, all of the above, right? It just seems a little artificial to unpack all of that. And you know, in some sense, sure, this dispute arises out of sovereign acts, but it arises out of a lot of commercial aspects as well.
Well, if I could, Your Honor, I want to reframe the word commercial has used in so many different ways throughout these areas of law. And the crucial thing here is private versus sovereign. And I have a couple things to say in response to what you just offered. One is that if you look at the US Constitution, there are so many clauses within the Constitution that are designed to facilitate economic activity. Mm-hmm. The Contracts Clause, for example, the Due Process Clause, the Takings Clause. These are all provisions in the Constitution that are about the sanctity of property and the sanctity of economic activity that are designed to encourage investment in economic activity. I don't think anybody would say that those are private law agreements. They are sovereign.
So suppose same case as this one, except Nigeria rather than Ogun State had entered into the framework agreement.
I think that if Nigeria itself
right.
had a contract with Zhongshan,
right.
then yes, then Nigeria itself would be engaged as a private law citizen, right? As a private law person that had engaged with them. Yes, and they would be, and they would also have breached. And I want to go back to the other thing that you said, which is that Nigeria was engaged in the breach of the agreements. It was not. It was not a party to any of the agreements. I think that's agreed.
Well, if the breach, all right, so let's tie that one down. And then, the breaches were sovereign acts by Ogun State, right? Which are attributable to Nigeria in international law.
Well, if I could, the international law attribution is not really pertinent here. The settled precedent from this court and from the Supreme Court is that kind of attribution, that the presumption of independence is not to be lightly overcome, including for jurisdictional purposes. And the Supreme Court has also said very clearly, I'm thinking here, for example, of the Amarada Hess case, that those international law obligations, whether there is a substantive obligation under international law and to behave in a certain way, conduct obligation, or to provide compensation, that does not constitute an enforceable obligation, enforceable through our courts. These are separate questions. And so whether the arbitrators were correct or not to find Nigeria liable in terms of the international law, its obligations to China under that treaty by attribution is not really the question. For purposes of deciding whether Nigeria is engaged in private law conduct to bring this dispute within the scope of the New York Convention, it was not. There's no precedent under the New York Convention for that kind of attribution. That is that's customary international law. That's not U.S.
So go back to my hypothetical where Nigeria has formed the what's it called, the formation agreement on the right.
Yeah.
In between the promulgation of the treaty and the breach, they formed the agreement to induce the investment.
Yeah.
You said they would be that would be a New York Convention award.
Yeah, I think if they were.
Okay, but on your first theory, I'm not sure why that would be, because the breaches claimed in this case are all treaty violations, not contract violations. And your test is just, is it sovereign or is it private? Those treaty violations are sovereign. So it seems to me on your theory, you can't explain why my hypothetical would be covered.
Do you mind if I was hoping to reserve some time.
It's fine, keep going.
So so in your hypothetical, Nigeria has engaged in breach of these agreements, and indeed, Ogun allegedly did, and in fact, Zhongshan has pursued litigation against Ogun.
They may or may not have, but the claims are predicated on breaches of the treaty. Failure to give fair and equitable treatment, right, which is the rough equivalent of substantive due process. Failure to give most favored nation status, the rough equivalent of equal protection. Expropriation, the rough equivalent of takings. And as you said, those are all government acts.
I see. So I misunderstood your hypothetical, actually. I was thinking about a case where the government has an agreement and engages in conduct that constitutes like a breach of that agreement. But if you want to hypothesize a government that has an agreement, and then the basis of the claim
Is treaty.
is no breach, but purely sovereign acts. In that case, I guess I would have to say if the conduct is purely sovereign, then yes, it would still be outside the convention.
I don't understand how you can reconcile that with the text of the bilateral agreement. Because a bilateral agreement has, it's interesting, two separate dispute resolution provisions. Article 8 is for disputes between China and Nigeria. That's the state-to-state sovereign activity. Article 9, settlement of disputes between investors and one contracting party. And so the treaty itself creates a remedy for an investing party against the government that signed this treaty to enforce the terms of this treaty as to the investors.
So Your Honor, I'm going to go back to Amarada Hess, which actually specifically
Can you just talk to me about what the point?
Sorry, good.
What I'd really like to know is how you read, what does Article 9 cover?
I mean, Article 9 is certainly about a dispute between either of the sovereigns and an investor. That doesn't make it a private law dispute. It is a dispute pursuant to a sovereign obligation of these two sovereigns. It does not say anything about.
That's what Article 8 is for. Article 9, you have a treaty here where two parties agree to create rights for and protections for third parties, the investing entities. And they create a distinct arbitration mechanism so that those investing parties can enforce their benefits under this treaty. That's what Article 9 does.
That is, it gives them the investor the right to proceed to arbitration. It does not say what that arbitration gives rise to an award that is enforceable under the New York Convention or in U.S. courts. And I would, so for example. That's right.
Wait, I want to slow down here. All right, so you agree that the treaty creates legal interests and protections for investors.
It does guarantee fair and equitable treatment, just like the
And more than that,
process.
non-discrimination, non-expropriation, there's a long list of things.
Right, all of which
that
are sort of
protects
comparable
those.
to U.S. Constitution.
And it gives them what we would call in sort of our language here, not only those rights, but a cause of action, an arbitral one, to enforce them. So is that relationship between Nigeria and its investors that the treaty allows to be enforced against Nigeria through arbitration, if there is a dispute concerning fair treatment, non-discrimination or discrimination, how is that not within the meaning of the Commerce Reservation for the New York Convention, commercial activity?
So two thoughts, Your Honor. Well, three actually. First is we have to start with Article 1, Section 1, that tells us that the New York Convention is about private law disputes, sovereigns when they are acting in private capacity. That's what everybody understood at the time of the convention. Second answer is that with respect to the U.S. additional limitation, Congress has offered its interpretation, which is that legal relationships are transactional in nature. This is certainly not a transaction
It's
between.
very much a transaction.
It
Created
is,
third-party beneficiaries. They've given them protections and rights, and they've given them a way to enforce them. And they've done it. These are investors. It's entirely commercial.
well, it is commercial in the connected to commerce sense, but it is not a legal
It's
relationship.
commercial, and you look at the nature of the protections. It's for properties, it's for dividends, it's
Yes.
for profits.
Mhm.
So it is exactly the type of commerce that's covered by the New York Convention.
But the New York Convention,
With
if I
the
go back,
reservation.
is private law disputes. This treaty has nothing to do with private law, which brings me to my third point. This is not the first time a U.S. court has considered an international convention, an international treaty that gave a
And you think it's private because it uses the word persons in Article 1 of the New York
Actually,
Convention?
I can go back to the adopting conference that says,
I don't know the conference, I'm going to tell you, we're in the text of the New York Convention.
Yeah.
That there's an even narrower entry into the convention for what you're calling private, that would be narrower than commercial relationships between a country and its investors.
so the New York Convention, as of, like document from 1958, was not designed for this, right? Like it was.
That's your position. I'm asking for evidence of that.
So first thing is, when they were considering it, the USSR and Belgium said, wait a second, this looks like the original title of it might give you the impression that this should be about states in their public law capacity. Everybody agreed that was not the purpose, so they changed the name of the convention. It was brought up during the debates, wait a second, could this be applying to states in their public law capacity, or should it be only states in their private law capacity when they engage in private law transactions?
I think what I need you to answer is why this type of investment and creation of an investment relationship between Nigeria and its investors, an enforceable legal relationship with its commercial investors, why that is public and not private.
Your Honor, it is public, sovereign as opposed to private, in the same sense as the contract clause in the U.S. Constitution or
I
substantive
don't think
process.
those are helpful, at least for me. Maybe
Sorry?
it's helping other people.
Yeah.
We're not interpreting a constitution here.
Right, we're interpreting a treaty,
All
but
right,
it
we're
is,
interpreting a treaty about investment that
Yes.
time and again in other cases, and even in the views of the United States government, has been recognized to allow exactly these types of arbitrations. And I don't see any more public. I think what you seem to be saying is the only thing that what makes it public law is that Nigeria didn't have a direct commercial contract also with the investors. Is that the only difference?
I think actually
That would make a difference for you.
that would make a difference. And what was the conduct that
Government enters into public interest contracts all the time. That's in their public capacity as well as in a private capacity.
they do, and actually.
Military defense contract. So I don't.
Well, actually, if I could go and come to that in particular, the Supreme Court has actually answered that question. The Weltover case, which is cited in the briefs, establishes the standard for what is private versus sovereign. What it says is when the government is engaged in the marketplace in the way that a private law citizen could, and it drew a line actually, it's in Weltover. It says, on the one hand, a regulation limiting foreign currency exchange, that would be private, that would be public. And then Weltover says further, the military buying bullets, which is exactly the thing you just described, that's private because anybody can buy bullets, even though they're buying it for a public purpose. And this court has said also as well, it's not about the purpose.
Private companies can enter into contracts with investors
They can.
and say that we will treat you fairly and nicely when we do so.
They do, although they don't enter with, the private companies don't undertake to guarantee fair and equitable treatment for the world at large, right? This is not the agreement here was not with Zhongshan. It was a promise to provide fair and equitable treatment across the board.
Are they third-party beneficiaries?
Um,
It's their interests that are protected and they have their own distinct and separate enforcement mechanism.
well, not
Separate
distinct.
yes, it's separate from the
is.
China versus Nigeria.
My point being, though, Your Honor, is not distinct to Zhongshan. It is across the board for the entire public that might invest coming
For
from China.
investing, it's for actual investors in
Yes.
Nigeria.
Yes.
And actual investors, were there any, these actual investors They're commercial actors.
Yes, but the
They're
government,
private actors.
yes,
And
but
are they the type of entities with which other private entities in Nigeria could contract
well,
for investment?
Your Honor, again and again, this court and the
Yes.
Supreme Court have said,
The answer to my question, I think, is yes, there are companies in Nigeria that could contract with these same investors, correct?
I would take for granted there are companies that contract with them. Yes, in
So-
fact, there are some examples in the record.
So the contracting that occurred here with investors is exactly the type of thing that a private entity could do.
What Zhongshan did is yes, but what Nigeria did is not. And if you look at so many of these cases from
What is
this
it you're
court,
saying that Nigeria did that a private company couldn't do?
well, so first off, promising fair and equitable treatment across the board, entering a treaty with China.
No, the treaty, this agreement itself treats the dispute, any dispute with China as distinct from
Yes.
a dispute with investors.
But the promises that Nigeria made were sovereign promises. No private party could have made these promises. These are promises to provide fair and equitable treatment as a government.
Private parties can agree to provide fair and equitable treatment to investors too. They can agree not to discriminate. They can agree not to steal their property.
They can, but they do that to particular
No, they could
companies.
have, here's our company policy. Any investors anywhere in the world, we won't discriminate. We won't steal.
Yeah.
We'll treat you fairly and equitably.
Although I will say that Nigeria entered that agreement, made that promise in a treaty with China, which Zhongshan has said
And
they
a
agree is
treaty
sovereign.
that I mean, if the treaty's only enforcement mechanism was disputes between Nigeria and China, you'd have a lot more force to your position. The problem is this agreement, agreement itself is an investor agreement focused on commercial development and creates rights for investors and a distinct arbitration enforcement mechanism limited to those investors so that they can enforce violations of the terms of this agreement against Nigeria, against a contracting party, is what Article 9 says. And I don't understand if you're saying all that means you have to have a separate contract. Well, that separate contract is going to tell how to resolve those contract disputes. So this Article 9 becomes an empty letter, I think. How does it not become an empty letter under your theory?
Well, so let us suppose that so there's an arbitral award. There are so many areas in international law where a country may have an obligation that is binding under international law, the Treaty of International Law, an obligation that is binding under international law that is enforced through international law mechanisms. WMATA Hess is an example of that, for example, in which the Supreme Court specifically said, the fact that these countries have a treaty-based obligation to provide you compensation does not mean that you get to enforce it in U.S. courts.
No, but we have law that says special things about when it's an arbitration agreement. And that's what you have here is an agreement to arbitrate. That's what kicks in the New York Convention.
Well, I mean, you know our position on that, obviously, but I would like to come back to something else that you said, which is that what Zhongshan did is very commercial. Of course, they are a private company. In every one of these cases about the private sovereign distinction, one side of it is a private company that is doing what private companies do. And yet, this court and the Supreme Court have again and again focused on what did the sovereign do to decide whether the sovereign was in which capacity.
If I understand your position is that this was distinctly sovereign because Nigeria made a global promise to investors.
Yes, a promise to China, like let's accept the third-party beneficiary, but it is global. Yes.
Okay, to Chinese investors for these purposes.
Right.
To Chinese, you're fair.
Yeah.
Globally to Chinese investors.
Yes.
That's what made it public and not private.
Yeah. Yes. And in addition, they made that promise.
Companies can't do that. Private companies can't do that.
I cannot think of an example where a company would make a public, like a binding promise to the world at large.
Well, you just said it's not the world at large, just to China.
Well, okay,
It's not whether they would, it's whether they could.
And then, but I also come back to the other.
Could they? Microsoft couldn't make such an agreement? What prevents them?
Well,
What about their private character prevents them from doing that?
the they would have no, the fair and equitable treatment that Nigeria has promised here is fairness and equity in how it regulates. It's not a promise about how they're going to buy goods. It is a promise about how they will operate as a government. Microsoft can't promise not to expropriate. It can't promise to tax people in certain ways.
We don't require, I mean, nothing would ever be private then when governments do it, because every government has, almost everything it does, even when it's participating in the marketplace, it does through sort of regulatory regimes, like the government contract we talked about. So it can't be that, that's not how we analyze it.
Well,
But they could, of course, Microsoft can agree to be fair and equitable in its treatment. It can agree not to discriminate between investing companies. It can agree not to steal their property.
it can, but it can agree, but it can't agree to do that. through
Arbitration, to be fair and
Right,
equitable in
right.
arbitration proceedings.
But it can't agree to do that by regulatory means. And I go back to Weltover
Where
and
does it
Nelson.
say it agrees to do it by regulatory means? in here?
Well, let's go back to it says, so Article 2, Section 2, investments shall enjoy the continuous protection. What kind of protection are they talking about? That is surely regulatory protection. That is not that Nigeria will contract in certain ways. It says, subject to its laws and regulations, neither contracting party shall take any unreasonable discriminatory measures. What measures is it talking about? It is surely talking about governmental measures. Measures is not a word we would usually use for, procurement or contracting. It then says, they shall endeavor to provide assistance in obtaining visas and working permits.
Mhm.
That is also regulatory. As I go back,
Companies do that all the time. They endeavor to provide assistance in obtaining visas and work permits for their employees. Be employees.
they do, and that they pay for it, right? But they don't issue the investments. And I go back to what Nelson said and what Weltover said, which is, so when you said that the line that there would be no such thing as private activity because governments, obviously, any time a government engages in procurement, it has also had its own regulatory, it has regulated the nature of the contract, right? But what Nelson said and what Weltover said is that the question is whether the government has engaged in the market in the way the private party does.
Under your theory, if they had a direct contract, if Nigeria had a direct contract with Zhongshan, and it failed to provide, it discriminated in its laws or regulations, or it engaged in unfair treatment through its laws and regulations, I thought you agreed that they would still be able to enforce this.
So,
Yes or no?
well, what I think if you're referring to the discussion I had with Judge Katsas.
I thought you backed off it.
Okay. What we had come to
You have a
was,
direct contract with Zhongshan.
they've got a direct contract with
And you
Zhongshan.
really, the way you end up violating it is because you, as a matter of governmental activity, discriminate.
Right.
Would that be enforceable under this arbitration agreement or not?
If what they have done is, as a government, is breach a contract in the way that a private party could, that would be private. If what they have done is purely governmental, it would be governmental.
They steal their property. Expropriate it. Is that the same? Is that private or public?
Well, I hate to steal angels on the head of a pin, but the stealing is a word with many meanings. That like expropriation.
Expropriate the property.
Expropriation is something that this court and the Supreme Court have repeatedly said is sovereign.
And so even in a direct contract between Nigeria and Zhongshan, that hypothetical, if the property is expropriated, that's not protected by, there's nothing they can do under this investment treaty.
Foremost McKesson is a really good illustration
Is
of
that a
this.
yes or a no answer?
It depends on the conduct of the sovereign. So
I told you what the conduct of the sovereign is. It expropriates their property and drives them out of the country.
If I may, you have actually not given enough detail about the conduct.
What do you want?
Because expropriation is just a word. Let me talk about foremost
Okay, well,
McKesson.
before you told me it was a specialized sovereign activity.
True, fair enough.
It seized their property and kicked them out of the country.
that will tend to be sovereign. But let me go
So
to,
that would be no enforcement whatsoever for those investors, even in a direct contract case, is your opinion?
no,
That would not, yes or,
sorry, no enforcement in US courts.
so it would not qualify under the New York Convention, even in a direct contract case?
If what they have done is purely sovereign, yes.
If what they have done is is seize their assets and kick their employees out of the country?
And if
Yes?
if I
Yes.
could, I want to answer your
I
question.
understand, but I don't want you to, because I need to clarify something before you
Yeah.
go on, and then I will let you finish the sentence, I promise. Okay, so your answer there is yes. That does not qualify under the New York Convention.
There's a reason that I'm hesitating about the yes, because it does matter the details. And I'm going to go back to foremost McKesson if I could, in which the mode of what was alleged to be expropriation was actually breach of contract. Like they took over the company's board in ways that just violated the actual contract between the sovereign and the private party. Or if I could go back to Dunhill,
They engaged in sovereign actions that breached a contract.
that did breach a contract
Mhm.
that a private law contract that they had. Or I go back to Dunhill, which is maybe 1976 case, in which Cuba did not have sovereign immunity because what it had done was actually just breach. It's like it like some people said they said expropriation, and the Supreme Court said no. What you've done in this case is the same as the private debtor could do.
Is it the nature of the conduct or the theory of the breach?
Ooh, very good question.
Because like imagine United States versus Windstar, right? The government does sovereign things, but the counterparty alleges breach of contract. Is that where does that fall?
It's a very good question. It's the nature of the conduct and what.
So even a Windstar type case where the counterparty is alleging breach of contract, no enforcement.
I actually don't know the Windstar.
If the breach is done through a sovereign act.
I don't know the Windstar case, so I don't know that like very well. So I don't know the facts.
Government promises certain sovereign acts,
Mhm.
forms contracts on that promise, changes the sovereign acts, counterparty sues for breach of contract.
So what I'm hearing is that what the government did, the government's conduct
They
was purely
They
sovereign.
changed the regulatory framework.
Yeah. If all
And
they've
that
done
was
is,
alleged to breach a contract.
yeah, if all they've done is purely sovereign, then yes, I think that would be on the sovereign side of that question. See that I've now.
Well, let me just ask
Way
you
less
too.
than
You got China, Nigeria, bilateral agreement, and, just as a more basic premise, it's meant to encourage foreign investment. So what I'm really finding difficult is that you're saying that Nigeria should not be responsible for upholding terms of the treaty within its own jurisdiction. So that's one premise. The other thing is that as I look to Article 2, it's called reciprocal promotion and protection of investments. So investments of the investors of either contracting party shall enjoy the continuous protection in the territory of the contracting party. And so essentially, what's your position signaling with respect to foreign investors?
Respectfully, Your Honor, I am not saying that Nigeria is not responsible. The question here is not whether Nigeria should be liable or whether there should be an arbitration. That's an issue between Nigeria and China. What I am saying is that the US courts do not have jurisdiction over Nigeria as a sovereign to enforce this arbitration award. Zhongshan is a Chinese company. There's no connection to this country. Zhongshan is a Chinese company that wants to enforce this award using the power of the US courts against this foreign sovereign. Whether Nigeria is responsible or not is a question, and what this means for the protection of of investment. That is a matter between Nigeria and China about the performance under their treaty. That's not a question of enforcing in the US courts, which I go back to again, Emirata Hess, which says, just because there is an international law treaty, just because that treaty tells the country how to behave, just because the treaty tells that country they have an obligation to compensate you for wrong. In that case, it was the Geneva Convention for the high seas. None of that tells you that you have the ability to use US courts to enforce that obligation.
But when it says there's an arbitration provision, that's where I'm struggling. So I take it your theory, which says we focus only on the nature of the activity. That means that all of our decisions where we have enforced arbitration awards arising out of investment treaties are error if the conduct, even when there's a direct contract, which I thought was your distinction in your brief, but now you have told us even when there's a direct contract, sovereign activity still isn't sufficient to allow arbitration, right?
Well,
What you just said.
this discussion has really fleshed out this distinction. In the briefing, neither side had thought we've been focused on the contracting. This distinction had not come up, but in those previous cases, we can go back and look, but I think actually in the vast majority of them, the conduct was also private law
Well,
conduct.
Republic of Argentina versus BG Group, the investment was dismantled through laws and decrees. In Crystalex versus Bolivarian Republic, there was expropriation. TAFNet, we had courts facilitating acquisition of shares in other companies. I think all of those would qualify as sovereign activity.
I think, if I recall, and I will get lost in the details. I apologize. But I think in Tatneft, for example, there is also private law activity with respect to the board that the country has.
Wouldn't have worked without the courts also supporting improper facilitation of shares.
But the question, so I think in all of these cases, though, what you are asking about is mixed conduct, in which a government has done some private law conduct and some sovereign conduct. There's no mixed conduct here at all. Nigeria has done no private conduct.
What is your best authority that the New York Convention's coverage of bilateral investment treaties, arbitration provisions for investors requires this level of granularity? I mean, if you're saying it's mixed conduct, I think your position still has to be to the extent as any sovereign contract, any sovereign activity, and that sovereign activity contributed, had some sort of causal contribution, it can't be covered. You can't say is your position that as long as you mix your sovereign activity with some private activity, then you don't get the sovereignty protections? Or are you saying that each of those cases, courts went through and said that the private activity by itself was the sole cause of the breach?
I don't think that in any of those cases, the courts went through that analysis at all, to be honest.
Is that the position that you think they should have taken?
I think that if it is mixed, if there is some degree of private law activity, then yes, you have brought yourself in. And I don't want to talk.
Wait. Okay, just to be clear.
Yeah.
If there's some private activity, then it doesn't matter.
By the government.
Sure. Yes, of course. There's always, like you said, there's always going to be on the other side.
Right.
If there's some private activity by the government, say 10% of it was, 90% of it was governmental. And the 10% itself could not have inflicted the harm without the 90% governmental. What would the answer be?
If you don't mind, I would rather not try to put a number on the line because
I'm trying to make, you may not want to, but I'm trying to make it crystal clear to you that sovereign activity was the driving force, causal force of the breach. So that's why I'm putting the numbers on.
Yeah, I see that. And to go
Your
back to
position would be?
My position would be that if there's, I mean, I can put together some standard about substantial private activity, but let's be honest, like this is not a question that in this context that courts have thought about before because the New York Convention was not designed for
what
this.
your legal position is and what its consequences would be were we to adopt it.
You don't need in this case to adopt a position about that line.
You need to be aware if we were to adopt your position that we have to look that what is determinative, even in a direct contract situation, is what the nature of the conduct is. We got to know what we're buying. We got to know what we're stepping into and what we're causing other courts to have to deal with in future cases. So You may not think it's a fair question, but I think it's a fair question to understand. You're the one who brought up mixed
Fair enough.
conduct as the distinction for these cases.
That-
I've got to deal with our circuit precedent. All right, so I do really need an answer to that, because I don't read in any of those cases a determination that the private conduct was either the but-for or the primary, pick your causal theory, of the breaches in those cases.
Yeah.
It just wasn't undertaken by this court.
Yes. Here is the, and like, to be honest, here is part of why I struggle with this. In Weltover and in Nelson, the Supreme Court says what our question is whether the government has engaged purely in the way that a private citizen could in the market. And as you observed, that theory doesn't quite make sense because no government is ever purely, they've always got the backdrop that they regulate their own private, like their own content of private law. But that is what Weltover and Nelson say.
And you
meanwhile-
used the word purely a lot in your brief, so you adopted that.
Yes. And at the same time, I'm aware that we have the Belize case that we've talked about in the briefs from this court, in which it is primarily private law activity. The government is selling assets, et cetera. And then one little corner of the contract is that as part of the exchange of compensation and consideration, both directions, they're going to give the investor tax preferences. So that is a primarily the government's activities are like the contract is private law. The activities are private law. In fact, I don't remember what the government's activities, but I don't think they've breached the tax preferences. As you know, this court says in Belize, we're not going to ask for the word commercial in the U.S. reservation. We're not going to ask about private versus sovereign. That's Belize, obviously. And you know our position about that and what has to be a legal relationship. But as I try to reconcile that with Nelson and Weltover, where the Nelson and Weltover line does not make sense even on their own terms to use the word purely, because for what you said, that's the struggle that I have, to be candid with you, Your Honor, about where to draw that line, whether one should call it. One cannot. I have certainly hewed to Nelson and Weltover. I have parroted the line from the Supreme Court, but I acknowledge that, as you say, like you cannot literally apply it literally in that way. This case, of course, we don't need to apply it in that way because there's no private law conduct and no, like in any sense, by Nigeria. If, however, you were to say, if you were to repeat the line from the Supreme Court, you'd probably be on safe ground, at least in adhering to it, even if that would be difficult to flesh out in a case that has got a
Future
serious
cases.
question.
So.
Yeah,
we
I
should
acknowledge.
write an opinion that we really don't know what it means in future cases.
Respectfully, Your Honor, that does happen, but the line about how to define what is mixed, like what to do in a mixed case, whether it's substantial or primary or purely or whatever. Even if you put a standard to that, it would have to be fleshed out if that case arises. If there's a case that comes up, if, for example, in Crystal X, if Venezuela had said, no, this is not a New York Convention award, and of course, in none of those cases is that dispute even coming up. I'm not saying those cases were decided wrongly, but as you know, if nobody's raised the jurisdictional problem and that the court's decision on it is not precedential. If in Crystal X, for example, Venezuela had said, no, this is not a New York Convention award in the first place, because there was some bit of sovereign activity, there is no way to write a standard that is going to decide what that should have been in all of those cases. It will always depend on the details.
Can your position here be reconciled with this third restatement of U.S. law of international commercial and investor state arbitration? And that restatement has some very bad language for you.
Respectfully, Your Honor, I think it can. So Zhongshan has really looked at two particular things, which I'll talk about separately. One is that definition of commercial, that definition is about the scope of what they are, of the restatement itself covers. That restatement covers awards that are, for example, under the ICSID convention, which is a totally different regime.
Yeah, fair enough, but it
Yeah.
says that for non-ICSID treaty-based arbitrations, not contract-based, treaty-based, you apply the New York Convention and the Federal Arbitration Act.
If you mind, I'm gonna pull up my copy here.
It's in 5.1 reporter's note. And 1.1 says you're in the commercial bucket, even if the sovereign is a party and the dispute arises from public regulatory acts.
Mhm.
And that seems to describe this case to.
Going to take me just one moment to get to
Sure.
5.1 because there's a lot of restatement. Got the general provisions here. Here we are, 5.1. If I'm looking at, for example,
Reporter's note, in the reporter's note,
yeah,
the word language for you, 1, 2, 3, 4, about 5 paragraphs.
yes. So, but if I could go back to the comments, here we are, the reporter's note. I agree with you.
Go
that
ahead.
This is
I
bad
had-
language.
You know, I
Yeah.
had thought one way to divide up the world,
Mm-hmm.
which you don't make a big deal of, but it's consistent with your brief, is to say private arbitrations, New York Convention,
Mhm.
public arbitrations, ICSID, right? Very
Yeah.
simple.
Yeah.
But this comment is putting non-ICSID treaty-based arbitrations under the New York Convention is inconsistent with that.
Yeah. So I'm going to go back if I could to comment C before we get to the reporter's notes. Comment C is,
Here,
has
in 5.1.
in 5.1, yeah. Comment C is titled Investor State Arbitration pursuant to an international investment contract.
Got it.
That's, a contract that did not exist between Zhongshan and Nigeria. An international investment contract is a type of commercial contract entered into between a private party and a state or its subdivision. The role of a U.S. court in connection with a non-ICSID convention arbitration arising out of such a contract is determined by the same bodies of arbitration law that govern the judicial role generally. Thus, when the ICSID convention does not govern, the obligation to arbitrate is subject to any applicable treaty. That word applicable hides a lot of sin.
Such as the New York Convention.
Such as the New York Convention, but the word applicable is telling you that you first have to understand well whether it's applicable.
Right, but 5.1 and some language in, sorry, I have a lot of paper too.
Yeah.
5.1 and some language in 1.1 seem to strongly indicate that we can be under the New York Convention if we're talking about disputes arising from public regulatory acts. And that phrase is from 1.1.
So 1.1, are you looking at the
Comment E.
comment B? Yes. Public regulatory, sorry, I'm going back to our, do you mean comment B from 1.1? That's arbitral tribunal. Do you mean comments E? Okay, thank you. Yes.
Even though the dispute arises out of public regulatory acts.
Yes. And that,
As opposed to contract breaches.
yes. So first off, that is about the meaning of the context, commercial for one thing, which doesn't tell us about Article 1, Section 1. It also says, so the restatement.
Fair enough, but it
Yeah.
doesn't make any sense if 1.1 carves out all, everything based on a government's public acts.
Well,
You'd have no occasion to ask about any of this.
That's fair, but this also points us back to, at best, to mixed cases. And, they're writing this, this is from last year, right? Like 5 decades
I
after.
mean,
the
one
convention.
answer is, right,
Right.
this is not how
Yeah.
things were understood in the
Right.
1950s.
That is a very important part of the answer, but they're also writing this in light of Belize. They're aware that, for example, this court dealing with that case in which there was a private law asset sale with a corner of tax preference in the agreement, held that it was subject to New York Convention. So the drafters of this have got to be dealing with that body of law. As you know, we don't view the Belize case as controlling for the reasons that we've said, but okay. Now I very much overstayed my welcome.
Any other questions? Great, thank you. We'll still give you some time for rebuttal.
Thank you.
Morning.
Good morning. May it please the court. My name is Jovana Tsuncevic, and I'm counsel for Appellee Zhongshan Fucheng Industrial Investment. Zhongshan respectfully requests affirmance of the district court's order finding subject matter jurisdiction under the FSIA arbitration exception and this court's well-settled precedent. Zhongshan's award against Nigeria relates to a commercial investment. Namely, Zhongshan obtained an arbitration award directly against Nigeria under the China-Nigeria BIT, which found Nigeria liable, among others, for expropriating Zhongshan's commercial investment in a Nigerian free trade zone and awarded Zhongshan more than $55 million in damages and interest. And the district court correctly decided, based on this court's precedent, that the award arises out of a legal relationship, whether contractual or not, that is considered as commercial per Section 202 of the Federal Arbitration Act, and that the FSIA arbitration exception applies. Now, Zhongshan had the initial burden of production to satisfy the FSIA arbitration exception, which it did, pursuant to this court's precedent in Chevron and Stillex. Namely, Zhongshan presented and alleged facts that show that there was an arbitration agreement between Nigeria and Zhongshan. And again, Nigeria does not contest this. And second, Zhongshan also demonstrated that it has an arbitration award that emanated from this arbitration agreement. Again, Nigeria does not contest this. And in fact, Nigeria readily admits and recognizes that the award held it liable pursuant to the BIT. And also, Zhongshan has met its initial burden of production to demonstrate that its award against Nigeria is or may be governed by the New York Convention. And Nigeria has not come even close to meeting its burden of persuasion to show that there's an absence of a factual basis by a preponderance of evidence that the FSIA arbitration exception does not apply. And there are 3 reasons that the arbitration exception applies and why this award is or may be governed by the New York Convention. And first, the award for damages to Zhongshan for Nigeria's unlawful expropriation and treatment of Zhongshan's multi-million-dollar investment in a Nigerian free trade zone is commercial and falls under the convention pursuant to the plain language of FAA Section 202.
Well, the word commercial, it's referenced in 9 USC Section 202, and it includes legal relationships, but then it gives a descriptor as a transaction, contract, or agreement described in Section 2. And then it also gives another descriptor saying that it includes any maritime transaction or contract evidencing a transaction involving commerce. So is the treaty treated like all other documents?
So, Your Honor, I would just point first to this court's precedent in Belize Social Development, also in DI Human, that really fleshed out the meaning of the term commercial in Section 202. And really, in the context of international arbitration, this court has held that commercial refers to matters which have a connection with commerce, that a matter may be commercial even if not contractual, so long as it has a connection with commerce. And here, the fact that Zhongshan was an investor that poured millions of dollars into the host state of Nigeria as the recipient of that investment, created a legal relationship under the framework of the protections guaranteed by the Bilateral Investment Treaty, and also by the extension of Article 9 in the BIT, which provided Zhongshan with an ability to directly pursue claims against Nigeria for mistreatment, various breaches of the obligations that it had. And in that sense, the term and the framing of Section 202 is very broad. Again, the plain language tells us that the legal relationship need not be contractual, whether or not it is. It also says that that can include certain specific types of relationships, a transaction, a contract, or an agreement, but is not limiting. And in fact, it is consistent to view the legal relationship between Zhongshan and Nigeria that is founded under the framework of the BIT as one, as Your Honor pointed out, that creates a third-party beneficiary relationship. And that is the important context for the enforcement of this award. And again, pointing to the restate.
Is that part of the treaty, Article 9, that's really focused on creating this, Article 9 read in light of the promises also made to investors in the rest of the treaty. In making that commitment to investors to arbitrate for violations of promises made in the treaty, and you guys may differ on the scope of those promises, was that public or a private activity? I get the relationship, negotiating with China, that's public. But that aspect of it that was creating what could be viewed as third-party beneficiary, both rights and means of remediation, is that a private activity?
If Your Honor will permit me, just to answer that question, I'm going to step back a little bit and flesh out what the framework requires and what it doesn't require. And so first, if we look at Chapter 2 of the Federal Arbitration Act, nowhere does it make a distinction. Does it talk about the fact that awards are enforceable under the New York Convention only in situations of private conduct or sovereign conduct? Indeed, it doesn't talk about the type of conduct at all. And I think that is particularly germane here because counsel seems to be arguing for a regime, but it does not cite any interpretations or any framing, whether it's in the FAA or in the New York Convention, that really fleshes out what role conduct here plays, or private versus public activity. And in that sense, even looking at the text of the FSIA arbitration exception, in which it talks about the types of actions that can be brought, it refers to an agreement made by the sovereign state with or for the benefit of a private party to submit to arbitration any and all differences. And then it expressly states that to confirm an award may pursuant to such an agreement to arbitrate. So there is a contemplation that there will be situations where a private party and a state will be arbitrating disputes. And in that sense, consistent with this court's precedent and the enforcement of investor-state arbitration awards, investor-state arbitration typically involves, and it does involve, breaches of a treaty. And counsel would create a rule that says, well, basically breaches of a treaty are always going to be considered sovereign acts, but it really is a distinction that is not rooted in anything that counsel can point to.
If you had a situation where the dispute were actually between Nigeria and China under this treaty, would that be enforceable in U.S. courts under the New York Convention?
So that would arise under a different article. And that could be a dispute, which could
Why
be
would it arise under a different article? You said person has a plain meaning and there's no qualifications and it covers states, so.
Yes, so it would arise under Article 8 of the China-Nigeria BIT and would be a separate dispute.
No, that would be that dispute, but let's say they arbitrate and then China wants to enforce that arbitration award in a U.S. court under the New York Convention. And there's no qualifications there. There's a legal relationship. Your position is person means state for purposes of the convention. And so what would prevent courts from enforcing, is it your position that that state to state agreement would be enforceable, arbitration award would be enforceable under the New York Convention and US courts?
So I think it would depend, Your Honor. And I think that the reason why it would depend is first, state-to-state disputes could have a public international law character that is different, and that could concern something that is not commercial. And so it would not fit
I'm
in.
assuming it meets the commercial reservation. I'm assuming that China brings a claim here. Let's imagine it was actually a Chinese governmental company instead of Zhongshan. And so China brings the claim instead of having this company bring the claim.
So in that specific scenario, if the party that may have some state ownership brings a claim directly against the state under the investment treaty, it could do so under Article 9, the same article that Zhongshan pursued in its claims against Nigeria. And then it would be a bit of a different analysis. And I believe the situation.
I'm assuming they're proceeding under Article 8 because it's China versus Nigeria.
And there have been instances, Your Honor, where if there is state ownership of a particular investor, where those could still proceed under Article 9 because of the definition of the
I'm
term.
saying they
investor.
proceed under Article 8, and they can have arbitration under Article 8. They get some arbitral award, and China now wishes to enforce it in district court here. Is it covered? What I'm trying to ask is, would that type of state versus state enforcement action be covered by the New York Convention?
I think that it would depend, Your Honor. It may not be, and
Why might it not be?
it depends what kind of.
I'm assuming it's also commercial.
If it
falls
is
within the commercial
if it is
convention.
commercial, then yes, it is. Reading the Federal Arbitration Act, that could be a possibility to the extent that it's not about non-commercial activity. But I submit that it would depend on the particular dispute and the particular situation.
The dispute is over interpreting this investment treaty, which is all about commerce. So state to state dispute about how to interpret a commercial treaty. That's covered. That's enforceable through the New York Convention.
Your Honor, I can't say at this moment. I think that there is a pathway in which it could be enforceable, but in terms of looking at the FSIA arbitration exception in particular, again, I would just point to the language that says an agreement made by the foreign state with or for the benefit of a private party. And again, understanding.
That's a separate sovereign immunity question. I think we're just asking about whether it falls under the New York Convention, which is
Right.
separate from whether there might be a sovereignty there.
Right.
Sovereignty immunity bar. So that first question, why wouldn't it fall under the New York Convention if person always means state, no exception?
It could, and I think that there are circumstances, looking at Chapter 2 of the
But you
FEA.
seem to hesitate. Why wouldn't it?
Your Honor, I think it would just depend on the particular type of, and I'm just being mindful of Article 8 and the type of interpretation that the two states might be disputing about. And I think that for the purposes of these types of investor-state
You're disputing
awards.
what fair and equal treatment means. Say that's my hypothetical. Or non-discriminatory treatment. They're disputing those things.
Right, Your Honor. And I think that there is a way in which two states having a dispute pursuant to this particular investment treaty would be enforceable under the New York Convention, depending on the type of dispute and depending
Has
on.
the New York Convention been applied in the past for a country versus country, state versus state dispute that you're aware of?
I am not aware of that having been applied, Your Honor.
And that's a real difficulty for your position, because the one thing that was crystal clear from the negotiations of the New York Convention, to the extent we care about the treaty equivalent of legislative history, is that the convention did not cover state to state awards. That was crystal clear.
Yes, Your Honor. And I think here, just wanting to bring it back for the purposes of disputes that are occurring between an investor and a state. So out of the realm of state to state, it is clear enough that in those situations that the New York Convention would apply. The term person has been interpreted by the Belize Bank case, by the district court, finding that essentially in circumstances where a private party is pursuing claims with a state, that in that scenario that the New York Convention would apply.
Person, if the word person in the treaty doesn't cover a state when it's arbitrating against another state, I mean, that is just to say, like, you know, you can't just rest on some dictionary definition of person to encompass state. It might or might not. And then you need to look at, and you can't get there from the existence of a private arbitral right of action under Section 9, because there's a private arbitral right of action. There's a state arbitral right of action under Section 8 of the treaty. So you just need to kind of go back to it's either background principles or what the negotiators had in mind, which is would the convention cover states? You know, do you think about this as more sovereign or more commercial?
Well, I think.
Sorry, go ahead.
Sorry, you're on. I think here, again, just stepping back a bit, if states have legal personality under international law, which they do, and just for the purposes of applying the New York Convention within the United States and in the framework that we know of, and recognizing that we don't have a framework under current U.S. jurisprudence for the application of state-to-state awards. That's why I'm just hesitating a bit, because I think in this context, at least it's fairly clear that looking at a circumstance where an investor brings claims against a state pursuant to investment treaty award, and that arises out of an investment in that state, that is well within the realm of a coverage by the New York Convention.
But why? I mean, if you were looking for a template of how to capture disputes between a sovereign country and investors of a different country, I mean, it would be ICSID, which uses all of those terms. It wouldn't be a convention that, you know, whatever you think its outer bounds are, the primary focus is on private arbitration, and it just uses this general word person. It seems an extremely elliptical way of sweeping in this whole category of investor sovereign disputes.
But so to answer that, there is certainly an ICSID convention mechanism, but it was not created in a
What convention?
ICSID convention. But it was not meant to supplant the application of the New York Convention. And in fact, many treaties provide for.
Well, it actually does. If something's enforceable through ICSID, it's not enforceable through the New York Convention.
Yes, but the arbitration agreement may provide for different types of arbitrations by different types of arbitral institutions. So for example, if it were an ad hoc arbitration like the case was here, that would not go through the ICSID convention mechanism. But there are other mechanisms, namely the New York Convention, that do apply. And the focus there is, as the New York Convention was implemented in the United States through Chapter 2 of the Federal Arbitration Act, Section 202 sketches out what falls under the federal arbitration, under the New York Convention. And it states that it is an arbitral award arising out of a legal relationship, whether contractual or not, which is considered as commercial, and that shall fall under the convention. And this court, again, has applied this in the context of investor state awards that have been enforced. And that is the framework that we are operating with.
The theory then that the portion of this treaty that sort of, or Nigeria sort of turns away from talking to China and turns out to Chinese investors and says, you have these protections and we will arbitrate with you if you please come invest in our country and help develop it economically. That is the state acting more in a private capacity than a public capacity, or private versus sovereign, I guess, capacity? Is that the theory of these cases? I get that there's lots of cases where this has happened, although I think they have all involved direct commercial contracts, but that doesn't seem to matter to Nigeria. But is a theory then that for you, since you don't have that direct contract, that this Article 9 and the protections it enforces are sort of like an aside in the middle of the treaty that speaks to and creates these third-party rights with commercial entities?
Thank you, Your Honor. So a couple of answers to that question. And I'll step to Section 202, which says that what is required is a legal relationship, whether contractual or not. And so in that sense, there does not need to be a direct agreement. And what is really necessary is to flesh out the relationship between the parties. And here the relationship is one where Zhongshan was an investor that poured millions of dollars into a free trade zone to develop it to.
Under the bilateral treaty, that's what I'm trying to ask, since you don't have a direct contract. Under the bilateral treaty, what is the relationship between Nigeria and Zhongshan?
That of an investor, Zhongshan, and the recipient of an investment, Nigeria.
I'm sorry, I'm looking for a label. Is it private or sovereign?
So that is in the context in which we have been discussing this morning.
Distinct from the China-Nigeria you have the China-Nigeria relationship in the treaty, and then you have this at least third-party relationship with investors.
Yes.
But you agreed up front, and Judge Katsas' reference is sort of at least background understanding that state-to-state disputes are not under the New York Convention. That's at least a background.
Right.
I don't know that there's case law on that, but that seems to be a background understanding. And so what I'm trying to understand is, does something change when it's no longer Nigeria-China?
Yes.
And you're talking about this investment relationship. Does something change that's material for purposes of the New York Convention if we assume that the New York Convention doesn't cover state to state? That's what I'm trying to understand is, was there some transition in the treaty, and is that a tenable reading of treaties?
Yes, Your Honor. So in that scenario, there absolutely is a different type of relationship between Zhongshan and Nigeria than between China and Nigeria here. And again, that is within the framework of China entering into the treaty for the express purpose to be able to foster investment. And as the preamble says, the BIT sought to be conducive to stimulating business initiatives of investors like Zhongshan for the purpose of increasing prosperity in both states. And so in that sense, there is a relationship that is forged there. And when Zhongshan goes and invests money to develop a free trade zone that was set up in part by and regulated in part by federal agencies of the Nigerian government, like the Nigerian Export Processing Zones Authority, there is a relationship that is created there, and there are obligations that Nigeria has toward an investor like Zhongshan to protect the investment and not to damage the investment, whether that be through expropriation, through a lack of fair and equitable treatment. And that framing is what casts the legal relationship between Zhongshan and Nigeria. And that's how the Zhongshan and Nigeria are not strangers to each other, because of how would Zhongshan have been able to pursue and obtain a $50+ million arbitration award against Nigeria. It was based on breaches of obligations that Nigeria owed to Zhongshan on the premise that Zhongshan was an investor. And the arbitral tribunal had to find that Zhongshan was an investor with a qualifying investment, which it did. And the qualifying investment is typically a wide range of a non-exhaustive list of assets. And that's what Zhongshan satisfied and the tribunal found. And I just, at this jurisdictional stage, again, all that is required to find subject matter or jurisdiction pursuant to the arbitration exception and this court's precedent is that Zhongshan has produced, and Nigeria does not dispute, that there is an arbitration agreement that has resulted in an arbitration award against it. There are myriad cases that enforce investor-state arbitration awards that are analogous
Do you
here.
agree that we have to find that Nigeria is a person under Article 1 of the Convention?
Apologies, Your Honor, if you could.
Is that part of the predicate inquiry?
So a part of the, so first, I think it is important that the Chapter 2 of the Federal Arbitration Act, which implements the New York Convention, does not at all exclude the New York Convention from applying to states and from being enforced against states. And so I think in that sense, it is material. Chapter 2 of the Federal Arbitration Act uses the term parties and allows one party to confirm an arbitration award that it obtained against another party. And so in that sense, the Federal Arbitration Act does not place any strictures on the type of person against whom an arbitration award
No,
can
but we
be
wouldn't
enforced.
construe the FAA to be inconsistent with the New York Convention, right?
Yes, Your Honor. And in this case, that
So
you
that just
wouldn't
takes
be.
us back to the question about the New York Convention.
Yes, and Zhongshan's position is that the ordinary meaning of the term persons includes states like Nigeria. And again, we have the restatement Foreign Relations Third that tells us that the principal persons under international law are states. And we have the United States.
Does the restatement address state versus state arbitration?
Yes, so the restatement has talked about state versus state taking on a different character depending on the type of dispute. If it's a border dispute, if it's a certain type of dispute, then that takes it out of, it's a different realm. It's a different realm.
It's hard to imagine how state versus state isn't always going to be imbued with a lot of sovereign capacity in their
Absolutely.
agreement, even if they are, you know, it's after World War II and we're building up Europe and we are helping to develop and flourish.
Yeah.
That was still very much agreements done in a sovereign capacity. And so I guess what we're struggling with is how that line changes or doesn't when it's sovereign versus an investor without any direct contract. But I think, again, your opponent here says same answer, even if there is a direct contract, and then we're just looking at the activity.
Absolutely.
Now, do you agree with that? It doesn't matter whether it's a direct contract or not. We just look at the nature of the sovereign activity?
So,
No.
no, Your Honor. So there doesn't need to be a direct contractual arrangement between the two parties. And I also submit that the type of activity is not what is the crux of the inquiry in terms of whether the commercial reservation applies, whether under Section 202 or Article 1.3 of the New York Convention. Simply, what needs to be of a commercial character is the legal relationship between the arbitrating parties. And in that sense, it takes conduct out of it, which is why it makes sense that investor state awards are enveloped because in this system, because there's a commercial character. There are disputes in connection with commerce per this court's broad framing. And the fact that the FSIA and taking the FSIA, the New York Convention, and the FAA as a whole, it has created a regime whereby investors can pursue enforcement of arbitral awards, again, that are not in the ICSID construct, because ICSID awards are very specific, that allows them to enforce those awards directly against the state. And so in that sense, this is why the United States has taken the position in 1980 in an amicus brief in the Liamco case that that there is no exception or there's no treaty-based exception to the enforcement of an arbitral award by a private party against a state.
They had a direct contract there.
Yes, Your Honor, but it wasn't necessary to the conclusion. So it
might have been necessary to the U.S. positions. We don't know.
Well, I think it's illustrative that even in the absence of hinging something like that on the presence of a contract, I think that speaks a lot, because there's and obviously if the investor state provisions and the bilateral investment treaty is creating a third-party beneficiary relationship, third-party beneficiary contract with the investor and the state, then that further imbues it with directness. But again, this is
a third-party relationship here under the treaty is commercial. I'm just trying to get, you think it's private? Or
yes. So the relationship between Zhongshan and Nigeria, the legal relationship, is one that, although it's through the vehicle of a treaty, it's private in the sense that there are obligations that Nigeria as a host state makes to Zhongshan as an investor who's a private party here who has made the investments. But in that sense, even looking at jurisprudence that is enforcing arbitration awards pursuing to the FSAI arbitration exception at the jurisdictional stage, especially, there isn't a discussion of whether the state was acting in a sovereign or in a private capacity, because what is underlying really and truly the relationship and what's underlying the enforcement regime is that investor state arbitration awards have been recognized by this court and others to fall within the New York Convention regime and to be enforceable. And that is all that Zhongshan is doing. It is not doing anything unprecedented. It is simply asking that its arbitration award that arises out of a commercial matter, that arises out of its investment, a multi-million-dollar investment being destroyed. And
Can I ask you may not know this, or maybe it's just not in the record. There was a direct contract with Ogun State. I don't know if I'm pronouncing that correctly. Yes. Do you happen to know if there's any reference in that contract to this treaty?
Actually, I believe, Your Honor, there was. I don't have that before me, but I believe that there was a reference, and if I may point you to.
Is that in the record, you think, maybe? Sorry, this is out of the blue, I know.
Yeah, I believe there is a reference to that in the arbitration award. If I can find that for you, that there was some expectation and mindfulness about obligations made under the China-Nigeria bilateral investment treaty. Absolutely.
Maybe you could submit that to us in a letter after argument, just so we don't take your time. It's hard to look.
Okay. Yes, of course.
Is that okay? Any other questions?
Yeah, just, I wonder how much of your theory or your position depends on using 2020's understandings projected backwards onto a 1958 treaty. I mean, you know, we're in a very global world. There are lots of investment disputes. I mean, the subject of government investor disputes is the entire topic of this new restatement. There's an ICSID mechanism for arbitrating those disputes, and then judicial enforcement is virtually automatic. So we've been kind of desensitized to those kinds of awards being enforced. But it's a very different world in 1958. I mean, you know, we're only a couple of years after the United States first accepted the proposition that a government could be, for sovereign immunity purposes, could be treated as private, even when it was engaged in purely commercial activity. So I just wonder, from the perspective of the time of the treaty, it seems like this would have been a very big deal to put this kind of dispute into a framework that really was focused on private disputes.
Thank you, Your Honor. And
There's a lot in there, but
two responses to that, if I may. And I'll first, I think, start with the context of what you mentioned of what was understood then and now. And I would submit that even the drafting history that Nigeria has pointed to does not necessarily prove its point. It does not evidence a consensus that the term states was meant to exclude states qua states or states that are acting in some particular capacity. In fact, that's nowhere in the text. And I would just call attention to the Supreme Court statement in G Power Energy saying that, you know, generalizations from negotiating and drafting history cannot be used to create a rule that finds no support in the treaty's text. Now, going back to that negotiating history, you know, we have a statement from Belgium that was referenced by counsel that stated that the clause should expressly provide that public enterprises and public utilities should be deemed to be legal persons for the purposes of this article. even though if their activities were governed by private law. But frankly, that does not tell us that persons are excluded when engaging in the type of acts that have led to this investor state award.
I mean, it suggests that the hard question in 1958 was whether to cover governments when they're doing private sort of activities, not that anyone would have thought you'd cover governments when they're engaged in sovereign activities.
And still, I think this is why the position is instructed, because, and this is a little bit difficult to understand from Nigeria's position, because if you have an act like expropriation, well, that is an act that is committed by a government, and it is sovereign. It is the taking of property in violation of international law. And that is, it's unclear whether the fact that that can be a sovereign activity, that is sovereign conduct, how that can overwhelm, or what that means in the context of this private versus sovereign. But certainly this court has enforced awards that arise out of expropriation and Crystal X, and as also a circumstance where there was no direct contractual relationships in Crystal X. The claimant was directly contracting with an entity. So it really is difficult to understand what here under counsel's test is dispositive and who decides. There's no framework simply in the case law to even tell us how does one apply this private versus sovereign conduct.
I mean, it might or might not be the right test, but there are all sorts of contexts in which courts have to distinguish sovereign acts from private acts. So, I mean, the argument that, gosh, this just isn't manageable doesn't move me very much.
Right, and so I would point here to Belize social development as a good example, because it discusses a case that was discussed earlier in the day, Weltover. And I think two things that are important here is also which FSIA immunity exception is invoked. And again, here, Nigeria has cited multiple cases that are exploring whether it's the commercial activity exception in 1605(2). Again, those are contexts where a party is bringing a direct claim for liability against a sovereign. That's just simply inapplicable here. And another reason why it's inapplicable, because it uses a commercial activity, which is different, and this court has interpreted it as different than the term commercial in the FSIA arbitration exception. And specifically, in Belize social development, the court has stated that Congress was not trying to codify whatever restrictive theory of immunity is evoked by the term commercial activity. When it was ratifying the New York Convention, this was not the intent. And that's why in the international arbitration context, the term commercial means something broader and means something more. And again, I think here, looking in totality at the FSA arbitration exception, which is giving the ability to pursue enforcement of arbitration awards directly against states. Again, the statute makes express reference to an agreement made by the foreign state with or for the benefit of a private party. That is a circumstance that we're dealing with here, that is well and satisfied. And indeed, the FSA arbitration exception only states that the award is or may be governed. And so at the jurisdictional stage, Zhongshan has met its burden of production, but again, the burden of preponderance, the heavier burden falls on Nigeria, and it simply has not shown by a preponderance of evidence, by burden of persuasion, that this arbitration exception does not apply to enforce Zhongshan's award directly against it.
Thank you very much.
Thank you very much.
Mr. Bradley, we'll give you 3 minutes.
Thank you. So a few thoughts. One is, I think you're right that Zhongshan's position cannot explain why a state-to-state arbitration would not be covered. It's been pretty well understood that it's not. The restatement of foreign relations says the following are ordinarily not subject to the New York Convention. Arbitration of a controversy of a public international law character, such as a boundary dispute, talking about that obviously, or a dispute about our interpretation of or performance under an international agreement. That is the restatement of foreign relations, obviously a different reporter from the other restatement, but there is some general agreement. That's one standard, performance under an international agreement. If I go back to the committee report on the New York Convention when it was being drafted. The committee that drafted it says this convention will be good because it will facilitate the enforcement of foreign arbitral awards while at the same time maintaining generally recognized principles of justice and respect the sovereign rights of states. And respect the sovereign rights of states. That's what they said right in 1955 as they were drafting it. That's what the drafting committee says. Judge Millett, I hear your concept that I think we're all agreed that the agreement with China itself was sovereign, but perhaps the promise to the investors in the treaty was private law conduct. I found the line from Welto.
Just asking the question.
Understood. Okay, fair enough.
I mean, if that same language were reproduced in a contract between Nigeria and an investor,
So
what
here,
would it be? If you, the
Yeah,
same
let-
language that we won't use our laws to discriminate, to unfairly treat, to expropriate, and if we violate this agreement, you can arbitrate it against it. That's the contract. Same words, but it's a direct contract with the investors.
let me read you
What
the
would happen
passage.
then?
Could I read you the passage from Weltover that answers this question?
Mhm.
The Supreme Court says, the question is whether the particular actions are the type of action by which a private party engages in trade or traffic or commerce.
Mhm.
So
We have a lot of cases in this court where, at least when there's been a direct contract between the foreign state and an investor, that we've allowed those to be enforced under the New York Convention. We've got a lot of those cases. And that's why what I'm struggling with on your end is you seem to resist the notion. In fact, you did expressly resist the notion that if this exact same textual provisions that are in the bilateral treaty are cut out and planted into a contract directly between Nigeria and Zhongshan, and the exact same conduct occurs, you would say that can't be enforced.
well, I would go back to
You
this.
would, am I right in understanding that, or have I misunderstood your position?
So we had there's multiple discussions about whether the direct contract matters or does not matter. And you see me being pushed around on that a lot because, and I'll admit it's hard because sometimes, lots of times the direct contract is very relevant. It does represent a way in which a government is engaging in the market. But I'm going to go back to this standard that from the Supreme Court.
I just want an answer. I
Yeah,
understand
sorry.
what the Supreme Court has said.
Yeah.
It's not helping me without some sense of application. So they
Yeah.
speak in a general sense.
So
Trying to resolve this case. So if
Yeah.
we take all the language that's in this bilateral agreement and we cut and paste it into a direct contract between Nigeria and Zhongshan for the exact activity that happened here, the exact same violations that they allege occurred here, and the same type of arbitration that they obtained here. So they get the award, but they get it for breach of a contract where that contract provided for arbitration. Yes or no could be enforced under the New York Convention.
the reason there's not a yes or no is that the hypothetical you just posed, again, does not have enough information. If, for example, Argentina has a bond that it promises investors certain things that might include that, that could be a contract that's private law activity. But so when you, in your hypothetical,
I'm giving you the facts, okay?
Yeah.
All right. All the facts are exactly what happened here.
Mhm.
Factually on the ground. That's the governmental activity at issue.
Right.
All right? It's the exact same factual activity. The only thing I'm adding in is that in addition to this treaty, there is a direct contract between Nigeria and Zhongshan. And that contract offers the exact same promises, except it's one-on-one now. It's not global. From Nigeria to Zhongshan against discrimination, against expropriation, against mistreatment, and promising fair and equitable treatment, and providing for arbitration for violations of these contract promises.
so, and what makes it hard is that what you just described is not a contract, but that a government would enter in the marketplace. It is a
Is that hard
promise.
for you or is that easy for you? Is your answer then, it's not equivalent to marketplace conduct?
It's
So
not, it's hard. It's not equivalent to marketplace conduct.
why is
That's
it
what makes
hard then? Why under your theory, you would say "Well, can't be enforced?
Because you could imagine circumstances where it could be part of engaging. And you go back to the Microsoft
I'm
example.
not giving you other
Okay.
facts. I'm giving you these facts. You
Yeah.
should be able to tell me.
Yeah.
Because these facts
Yeah.
are exactly, you know exactly what these facts are.
I know exactly where you're going, yes. So let us hypothesize then that Nigeria
I'm
writes
giving you the
documents. Yeah,
hypothesis.
right. They write a contract for everybody. That's like, sorry.
No.
this-
The contract's
sorry.
between Zhongshan
Sorry.
and Nigeria, not everybody.
Right, sorry. They write a promise to Zhongshan that says those things.
Yes.
That
And
sounds
includes an
to me,
arbitration
right.
provision.
That sounds to me like things that a sovereign would do. That sounds sovereign, not private.
And so
because-
they get all this investment and everything, and then, but you're still gonna.
So
Okay.
I
get it. You're saying that the promises in this treaty are
Are
all
sovereign.
sovereign. Doesn't matter if they're in a direct contract or in a treaty for your purposes. They can't be enforced.
because of its sovereign character, yes. Now, governments do
Because
engage in
of
contracts.
the activities sovereign character.
The
The
activity,
promise, sorry, the promise,
the promises,
activities are in activities.
Yeah.
Treatment or don't discriminate.
right. In your hypothetical, the promise is sovereign and the activities, like the expropriation remains sovereign as well in your hypothetical. So yes, it remains sovereign. The reason that I keep hedging is because you can imagine, as you said, Microsoft could write a contract to somebody that says, I will treat you fairly. Right? But they're doing that in the context of engaging in the market as a private player. And a government could engage in the market as a private player. But if all Nigeria does is it writes an agreement to Zhongshan that says, I will treat you fairly, there hasn't been
I
an
won't
engagement in the market.
discriminate, I won't expropriate.
All the rest of it, yes.
And in exchange for these agreements, I'm getting $50 million worth of investment from you. And I have obtained that $50 million worth of investment from you. And now I'm breaching it.
When we say Nigeria has obtained,
Yes, just like
Well,
happened here. You got. it's
yeah,
all in
well,
there.
I want to be careful because
Well, it can't
there's,
matter if you're asking about enforcement up front or after the fact. Nothing's changed other than you've actually gotten all the benefits of this agreement without any obligations on you.
again, when we talk about the benefits, there is in so much of US law, there is a difference between the government as a regulator and a participant. Nigeria did not receive, Nigeria, the people, right? Like the economy of Nigeria, somebody with, Ogun, in fact, received a contract with Zhongshan whereby Zhongshan put in however much money. It wasn't actually 50 million, but Nigeria is not a contracting party that received any money.
No, under my hypothetical, it would be. Investment would result.
Right.
Investment result.
Right. So that sounds actually very much like something like some aspects of the Belize case, in which Belize says, I'm going to sell you these assets for which you're going to pay me $50 million, or whatever the number is. Right. That is, Belize has entered into the market as a private actor.
Doesn't sound something like Belize under your view, because I've told you what the conduct is that is breached,
Right. Well,
which you
yes.
said is all sovereign.
Yeah. And I go back to, well, you know where I go back to.
How do you reconcile your invocation of Weltover with a pretty clear statement in our Belize decision that we just don't apply that standard in figuring out whether the New York Convention covers sovereign/investor disputes?
Respectfully, I think that's not quite what the Belize decision said. The Belize decision says we are not going to apply the Weltover line or interpreting the word commercial in that section 202 reservation. There is nothing in the Belize decision that talks in this Belize decision, there's a lot of Belize decisions, the one we're talking about now, that talks about the basic line that the New York Convention in the first place doesn't encompass states acting
You
as
can
sovereign.
use that line on your first point, but not your
Yes.
second.
That's right. Although, exactly. And the second thing I would say
On
about the Belize,
person, but not on commercial.
yes. Although the
So the
second
problem in
thing,
Belize was they just didn't make this person argument, but if they had, it would have come out exactly the opposite.
they did engage in very private law activity as well, though, Your Honor. They've sold assets and they received payments directly to the government for those assets. It was very much engaging the private market. And the breach that was alleged,
What assets did they sell?
I think it was, if I remember correctly, state telecommunications property. Like there was a governmental nationalized,
State community. Telecommunications, selling state property, that's not a sovereign thing to do.
No, I would think of that as being it's just selling assets. Like they sold assets. They had telecommunications equipment and an entity that does telecommunications. They sold that to a private party, and they received payment in the ordinary sense.
So
And
they gave land to Zhongshan to develop.
Nigeria did not.
If, again,
Sorry.
for now, I'm going to drop the Nigeria-Oregon distinction, all right?
Okay.
Nigeria, that's back into my hypothetical contract, gave Zhongshan land to develop. As to that, they can arbitrate. And that can be enforced here. Not where they can arbitrate, they can be enforced.
That sounds more. That does get more private, Your Honor. I agree with that.
More private or not, you just said selling stuff.
Well, the reason I keep resisting is because what is private, what is sovereign, depends on what's going on in each case. And
Sold
so you take
land.
it. Right. If they sell land, that sounds private.
Land doesn't belong to Zhongshan, must be under the control of the Nigerian government if they're selling it.
Right. Nigeria's got some land. They sell it. Sure. Sale of land, that's private. They own some
So-
land, they sell it.
And then they boot Zhongshan off. So if they sell it, and they don't give it to them, they can enforce it.
Well,
If they sell it and then boot them off, they can't enforce it. Is that the difference? Because the booting off would require police forces.
And there's this court has cases on this line. I think Wrong versus Liaoning, for example, is that involves commercial activity, but then the expropriation was sovereign. But if I could go back to to Belize, there's a second thing about the way in which Belize doesn't control this case, which is that in the Belize case, again, the one we're talking about, there's unquestionably a legal relationship. There's this sale of property under which the buyer is going to be paying Belize various amounts in exchange for the sale of property. Like that is whether, and again, it doesn't have to be a contract because contract is a technical word under some legal regimes in some countries, but it's an agreement. There's a transaction. So Belize doesn't even have to, the court didn't have to ask the question whether there was a transaction in that case. Nobody brought it up because of course there was. Whether that transaction, and all Belize says is that transaction, you don't get out of that by saying there was some sovereign conduct in that transaction. You don't get out of that in terms of the US reservation, but we still have to ask, what does legal relationship, which is considered as commercial, what does legal relationship mean? You still have to look at those words in section 202 and in the commercial reservation and in the convention.
I thought your argument wasn't about legal relationship, it was about the word person.
It's about both. One of them is section 1 in the brief, the other is section 2.
Any other questions? Right, thank you
Thank
very
you.
much to council for being submitted.
Case number 23-1075, Brookfield White Pine Hydro LLC petitioner versus Federal Energy Regulatory Commission. Mr. Warner for the petitioner, Ms. Gal for the respondents, Mr. Martin for the intervener, State of Maine.
Good morning.
Good morning. My name is Matt Warner. I'm here for Brookfield White Pine Hydro. I guess this case will swing us back to something like a local discussion from the global. I wanted to start with the observation today that this case can really turn on whether the word "and" means "and" in EPA regulation. The rule we're talking about here, generally speaking, requires a state to include three things when it denies an application for water quality certification. Those things are the specific water quality requirements that were not met, generally speaking, why those were not met, and if the state thinks it needs more information, like Maine does here, it needs to identify what information could be provided that would allow those requirements to be met if the applicant chooses to apply again in the
That's
future.
not how it's phrased. I'm going to ask you something. Your argument's about and. I'm going to ask you about will not comply. Does will not comply mean that they must show that it will not comply?
Will not comply, let me take a step back. Will not comply does mean they need to show that it will not comply, but that there are a couple sensible ways to understand what that could mean.
I don't want to get sensible. I want to get to plain text. So like, so they have to be able, how can someone, if they don't have enough information to decide whether something will comply or not, then be able to explain how something definitively will not comply?
Yes, well, that happens to be the way water quality certification works, Your Honor, is that it's.
I don't think so. I think the way it works is that normally states find, just as it says in Romanet 3, that the company, you, for example, in this case, have not shown, you haven't shown or assured that the discharge will comply. That's very different. Saying someone hasn't met their burden of proof to show that it will comply is very different from a state bearing the burden of explaining why it will not comply. So that's not how water quality works generally.
Well, the state can meet that burden by simply identifying the requirements that are not met, that with the
They don't
information
know if
the
they're met.
applicant
They
has.
need information to know whether they're met. They don't have information yet to know whether they're met.
Well, if I could bring it to the specifics of this case, then I can speak in the abstract again. In this case, we're talking about a 6,000-page application for water quality certification, one that was more comprehensive than a prior application that the state had denied in great detail over 54 pages, stating specifically which requirements were and were not met by that prior application. Here, the state had more information and yet
The
decided.
draft denial, is that the draft denial?
This was a draft denial in
Okay, so they
2021.
didn't actually lock it down yet. It was just.
Correct. It wasn't a final order, but it was the state saying in
There were final
detail.
findings there, so, okay.
There were findings that were there. Correct. There were not findings locked down, but there were findings that the state made over
That's the whole
54
point of drafts.
pages. Pardon me?
The whole point of drafts is that we can think about it some more.
Yes, and
So, anyhow,
The-
so you had a long application.
correct. A long application with
And they
great
said
detail. This is not. I guess
You
my
didn't have
point is
enough
that.
information
Right. My point is
yet
that
to
this.
tell, in part because you just dropped a whole new information on us just a couple of weeks ago that we haven't yet had time to analyze. How are they supposed to say, you just dropped this new information on us? They called a late stage submission that we have not yet had time to analyze. How are they supposed to, in one breath, say that and say, we can tell that you haven't given, that you're without more information, it will not comply? How are they supposed to do that?
In this case, the state could have issued an order that met the requirements of this regulation by saying there are federal processes ongoing, things that said in this order, and so we don't have enough information yet until those processes conclude.
But is
But-
but is the not enough information only the federal processes or what you all have not provided?
We're obviously not challenging the legality of the state saying we don't have enough, we don't have enough information premise for the denial. We are challenging, though, the state's ability to do so without providing the information required by this rule in addition. And I'm suggesting that that was perfectly possible here because the state could have said, we have this 6,000 pages from you, as we decided last year with a less comprehensive application. With the information you've provided to date, you don't mean this requirement, and this requirement under state law.
But they
Here are the
had-
reasons
they
why
said
we-
we haven't had time to analyze this new information. They said that. We haven't, this was late stage submission. We haven't had time to analyze that yet. And so
Yeah.
how are they supposed to then say, nonetheless, we can definitively assure you that it, I get maybe they can point to the requirements, but for purpose of Romanet 2, how can they say colorably and with integrity that it will not comply if they haven't had enough time yet to analyze it?
I think there are 2 points. One is the supplement we're talking about here, the quote, late stage submission
Mhm.
was a fairly brief, it was a 60-page supplement. It sped up the timing of certain measures being implemented by White Pine, but even setting aside.
They said on J 294, these have yet to be analyzed.
Correct. And so even setting that aside, the state
I can't-
didn't have time, assuming the state didn't have time
Assume
to
they
analyze.
didn't have time to analyze that.
Right, then the state still could have said, but the 6,000-page application we do have in front of us doesn't meet these requirements. You need to reapply when you have more information, including the supplement that we didn't have time to analyze. That would have been
So they're
acceptable.
supposed to, so they were supposed to, so what you say they waived here was just their ability to respond to the initial application, not the application adjusted by the September submission.
Well, the
That's what you
application,
just said. So if they waived anything, they just waived the response to your initial, what'd you say, 6,000-page submission? But they have not yet, and you don't dispute that they have not yet waived or have, have properly not yet analyzed that 6,000-page as supplemented by your September submission.
I don't dispute the state's ability to deny for lack of information and perhaps to do so on the basis that information has been late filed. However, what the state waived here was its ability to issue water quality certification at all for that project. The reason
For the
being
whole
that
project, I'm very confused. I'm very confused. What were they supposed to respond to in compliance, as you read this rule? Was it the problems with the 6,000-page initial submission? But of course, it was perfectly fine for them to say, we haven't had time to analyze the supplement. And so they were supposed to talk about how a no longer relevant submission didn't comply? That's what you say they had to do, and they didn't do it. So they waived their ability to respond to the no longer relevant submission because you yourself have changed it. Is that your position?
Well, Your Honor, we certainly don't care.
I'm telling you how I'm describing. What's wrong with my description?
Several things, Your Honor. First of all, it's not that the initial submission was no longer relevant. That was the relicensing proposal the state had to consider. This late stage
No, it wasn't.
submission made minor, it was a
Well,
made
now you want to say
minor
minor,
tweaks.
but oh, they came after they had given you a draft. And they were informed by at least conversations you were having with the Marine Service on their biological opinion. I don't think these were just commas. Did it change anything about how the hydropower program would operate?
The late stage submission sped up the certain fish passage measures that were already proposed, the
that
timing
relevant
at which they would be.
Is that relevant to the safety of fish going through?
It seems to be, yes, but the
Okay,
point,
so
but
it
the
was
point,
relevant to the concerns that had been flagged.
yes, we're not
So
disputing.
it's not, it wasn't an immaterial, it was a material changes.
Sure, and we're not disputing the materiality
Not
of
6,000 pages.
of this late stage submission. We're the state's denial by not providing the details required by 1 and 2 of this regulation left Brookfield without any idea what it needs to do to actually obtain certification when it reapplies it.
You knew you still had you knew they still hadn't considered your submission as amended by the late submission. You knew they hadn't even considered that, so you might as well wait for them to consider that. You knew that was still pending before them.
Correct, but the purpose of these rules is to tell the applicant what it needs to do to reapply and obtain certification, what information it can provide, how it can adjust its proposal, and the state was obligated to
Should have said
consider.
It was fine if they could have said, that's late, so we're not able to consider that, but thank you for giving us now an updated submission. Is the clock reset?
If the state truly couldn't analyze these minor tweaks in the supplement.
Okay, it can't be both minor tweaks and material changes for purposes of salmon preservation. You can't have it both ways.
Correct.
All right,
So-
and you said you made changes that in your view would promote the salmon preservation concerns that they had.
Correct. These were
Okay, so we're not
adjustments to
gonna
the
call it
timing.
minor
So,
anymore.
so if the state
material-
truly,
You don't dispute them when they say they had yet to be analyzed by the department, right? You're not impugning their good faith.
I'm not disputing the department's good faith, but I am disputing that the department's view and FERC's view that the department was not required to say what about the applicant's proposal it had before it for the full year provided under the Clean Water Act. What about that proposal failed to comply with state water quality requirements?
Where does the rule say that when the application has been, I'll just call it amended, maybe you have a different term, but has been amended, updated, supplemented, materially changed. That there's something in this regulation that requires them to go through these steps as to the old, now displaced application.
Well, the application wasn't old and displaced, Your Honor, and the supplement to
It's
this
been- It's
application.
displaced now by the one that is, we have A, application A. And application B is that application, but changed, materially changed by the September submission. And I think you've agreed that they can't be deemed to have waived their ability to respond to that, what I'm going to call submission B, which is A plus the material changes from September. They can't have waived that, their ability to respond to that, which must mean it's still pending before them.
Well,
But your view is we can lob all this stuff in late, and then we still expect you to answer this thing and spend your resources analyzing systems and aspects of its operation that are moot.
this
Is that your position?
our position is that it's consistent with, it's routine in water quality certification and FERC relicensing of hydropower projects in general, and especially on rivers where there are endangered species, that consultations are ongoing throughout the relicensing process. And the result of those consultations is that proposals do change and evolve over time. So it's not unusual for over the course of a year, a state has to consider an application for water quality certification, that there would be supplements filed and that the applicant, Brookfield here, would inform the
You haven't
state.
answered Judge Millett's questions with respect to the clock, restarting. So how does that fit into what you've just stated? If it's not going to be unusual for all of the supplements along the way, or for you to get a denial without prejudice and then withdraw your application and then supplement it or refile, then when does the clock restart?
Well, the state has a year to act on an application for water quality certification. It had that application here. Perhaps, I don't think there's been any case law on this point, but perhaps the state is permitted to disregard supplements like the one filed in September by Brookfield here, but
Why
you still
would
have to
you
act
want
on the
that?
application itself within a year.
That makes no sense. You yourself have identified whether it's Maine's concerns or you're concerned about the fisheries service. You guys have already decided, we're not going with plan A. We want to go forward with plan B. Lots is the same. But as to the salmon concerns, material changes have been made. We wish to go forward with plan B, but I've taken your position to be, but this regulation, and this doesn't have anything to do with the word "and" as far as I'm concerned, requires states with their limited resources to first spend a whole lot of time telling you what was wrong with plan A, including probably the parts you've already changed. That's what they did. That's the problem. And because by not doing that, they don't have any authority to act on plan B. That's your position.
My
Yes?
position, yes, my position
That's
is
your
that,
position.
my position is that the state needed to identify what was wrong with Plan A. That's
Even
important,
though it
but
was
it's,
including the parts that were moved.
well, so Plan B is a material change and slightly more protective for Atlantic salmon. It's not true at all that had the state provided the information required by 1 and 2 here, that wouldn't be helpful given the supplement to the proposal.
Could requiring, just quickly, could requiring what the state thinks you should do essentially just revert you back to what the specifications are, like almost an application process? Just the various specifications that you're putting forth the application for in the first place. Like they're deeming it insufficient information. You know what the specifications were required. You don't have some of those there, so why would the state do anything but just revert back to what the specifications were?
The problem, Judge Childs, is that we have no idea what the specifications are here because the state's position on that has evolved over the past 4 years, especially when we're talking about fish passage. This leaves us with the real world problem that we simply don't know what the state is requiring now, a problem that would have been solved had the information in 1 and 2 been provided. Now, specifically, the draft denial, which we spoke about earlier, suggested that the state would impose a 99% passage rate for Atlantic salmon up and down the river past the Shawmut Dam. Following that draft denial, the state filed documents with FERC noting that it instead wanted something called a nature-like fishway, which routes a portion of the river around the dam. In later filings, in earlier filings, several years ago, the state called for outright dam removal as the only way to satisfy state water quality standards. The result is that because the state's position has been constantly evolving on what's required for fish passage, we simply don't know.
What did your
What's
material
required
changes
here.
in September propose? Which of those options, or was it a different option altogether? Did you
It's,
propose?
our material changes in September were the result of consultations with, it's a different option altogether, a result of consultations with the federal resource agencies and FERC, and landed on a fish passage standard that has been endorsed by the federal agency through a biological opinion last year and the draft EIS recently. These were entirely different from what the state has said it will propose. The state has also at times suggested it will follow the lead of the federal agencies, but we simply don't know which of these the state's going to land on. So the fact of the matter is that
You didn't give them time to evaluate your new proposal, but you still think they should go back and evaluate your original proposal.
Well,
How
this-
does that help you, since that's no longer what you're planning to do? Because
Well-
even whatever they want, you still also got to make the fisheries service and the FERC, and at least in its EIS, content with what you're doing as well. So why does it, I don't understand how them saying something you're no longer planning to do shouldn't be done. Gives you any information, because you already decided we're not doing that, whether it's from their input, fisheries service input, FERC input, all of the above. You're
Well,
not doing it.
everything in the original proposal, Brookfield was planning to do, just a few things they're doing a little sooner than they said they would. So the material, the
You said
adjustment
it's material.
was,
And that you adopted an option that had yet to be discussed, because it was something that you got the idea, I guess, from the fisheries service, because we didn't have the EIS was further down the road at that point. And
correct,
so it was, so you sort of did door number 4.
correct, Your Honor. And if the state had, let's just say, if this denial had provided the information we wanted, it would have said, denied for lack of sufficient information. It presumably would have mentioned the supplement if the state didn't have time to consider it. And then it would have said,
Which it did say. Go ahead.
correct. And then it would have said, failed to meet this particular wildlife or habitat standard under state law, as the draft denial did in 2021. And it would have said, because,
So you already knew that. You didn't need that information.
well, as I just explained, we didn't know exactly what would be required because the state has changed its position repeatedly. And
They
so-
don't have to tell you exactly what's required. They just have to tell you why you're not meeting a requirement. Too many fish are dying. See, and then cite the specific requirement.
Correct. And had the state
How
provided
many
us
fish
with
would
the,
die?
well,
For ruminant too?
yes, I don't think the state was required to provide with exact specificity its requirements, but presumably the state could
Yeah,
have.
they just have to cite a
it done with-
requirement. I guess there's a requirement in law about protecting the salmon or something, or fish protection, and why it won't comply. It's too many salmon to die.
And had the state here identified which of the 3 or 4 state water quality requirements related that bear on fish passage of Atlantic salmon in particular, which of those were still at issue with this updated and more elaborate proposal that was more protective of fish? And it had,
No, wait, sorry. Are you saying they also had to go on, did you just say they had to go on and say why they still aren't met by your updated proposal?
no, forgive me, I'm
No,
speaking.
we're not saying that.
The relicensing proposal that the state had a year to act on, even setting the supplement aside,
Mhm.
was more elaborate than the proposal that the state had previously, issued the draft denial
Right.
related to.
Right. You
And
withdrew
so-
one and then you did another one.
And so the state could have
Round number
said,
3.
so the state could have said, this 1, 2, 3, or 4 state water quality requirements related to fish passage are still not met by this proposal with the information provided, because 95% of salmon need to get past the dam, or because we think a nature like fishway is required to meet state
I mean,
requirements.
that would be ideal for you, but I don't know where they have to do that. They just have to say why it will not comply. And I thought you just agreed if they say too many salmon will die, that would suffice.
I think even providing that information would have been helpful, because as it currently stands, we simply don't know if the proposal that the state had in front of it will meet state requirements or not, or if the proposal that is being considered by
But
FERC.
it's a moot, this is what I keep struggling with. States have very limited resources. And often far less than the federal government. And it's no longer your proposal. It's no longer the proposal you're putting forth.
It-
You've changed it in September.
Well, practically speaking, it gets us 99% of the way there. These minor material adjustments to the timing of this.
Minor and material, I'm sorry.
Yeah.
Not working, because you said it was a whole new option that they hadn't even considered. But it had been, I guess, endorsed by, I don't know any of this is true, I'll just assume it for these purposes, by the fisheries service. I don't think it's fair to call that minor.
Well, I think it's,
Material.
well, I guess 2 points. One, it would still be helpful and give, as this rule was intended to do, give Brookfield the information it needs to know if it needs to adjust its proposal at all to meet state standards, or if it can rest on the proposal before the federal agencies.
That's what analysis of your September submission would certainly be helpful for.
Well, if the earlier submission, from the prior October, the state had said this does meet state standards, with the exception of this one.
Which you knew from the draft denial that you were probably in trouble, but you wanted them to say definitively, we meant what we said in the draft denial.
Well, unfortunately, we don't know from the draft denial because the broader political context here led the state to also suggest that it would abandon the 99% standard and follow the lead of the federal resource agencies. Something we don't know if that's still true or not because this information wasn't provided here.
On the question about changes, can you give me any general guidance on the question when the submission of a supplement will or will not restart the clock? Because I mean, it just seems really obvious. If you're just dotting an I or crossing a T, like fine, maybe the original deadline holds, but at some point, the supplement will be so substantial as to just overwhelm the original submission. And it just can't be that nothing changes at that point. So how do we distinguish those two?
Yeah, so I mean, Brookfield's view remains, and this is what it said when it filed the supplement with the state, that it was non-material. I'm taking that it was material I'm taking it for the sake of argument here, but Brookfield did say when it filed this with the state that it was a non-material supplement that made minor adjustments to the proposal. The state then found in its order a decision that is not challenged here today, which is why I'm taking this materiality for the sake of argument here, that it was material and significant. That's something Brookfield disagreed with and could have, that's something that would have to be determined on a case-by-case basis, presumably at some point.
Doesn't have to be determined in this case. You agree it's material and significant.
I agree it doesn't have to be determined in this case, and I don't believe this would be the court.
So I'm sorry, if we're taking the case on the assumption that the changes are material, why wouldn't they have started a new clock?
Because this regulation, either way, requires the state to act on the application it had before it for a year.
I guess I'm where Judge Millett was then. I mean, if you've
We have
materially amended it.
We have more questions?
Just one more. So put aside the amendment. Let's just talk about what the reg means. So suppose if we read the and as an and, we sort of have to read will not comply as something like you haven't met your burden of proving will comply, right? If we do that, maybe the denial has to show all three, but I mean, what's the point at that point? They're just going to say, here's a list of all of our water quality standards that we care about. And the reason why you haven't met your burden of proving compliance is we haven't had time to assess this. And that's our, list out all the code provisions for Romanet 1, and that's the explanation for Romanet 2, and there we are. And it just seems like a kind of pointless exercise.
And you're discussing when the denial is due to insufficient information, as here?
Yeah.
Yeah, so I think in that case, the language in Section 3 does a bit of work too. And requiring the state to describe the specific data or information needed to assure that the discharge will comply with water quality requirements. When you combine those three pieces of information, you must know what information you need to, you'll know which requirements you failed to meet and why, even if you didn't meet your burden, but then you also know what specific data or information the state needs so you can meet that burden.
I guess I understand there's a question about how much information Romanet 3 requires. I guess I'm more focused on the question of what work Romanets 1 and 2 are doing in a kind of case like this.
Well, I think in a case like this, we'd at least know which specific water quality requirements we're talking about, and it would give us at least some idea, as these rules were intended to ensure of how.
I'm just going to list all of them and say we don't know whether or not there's a problem because we haven't had time to assess your submission.
If that were true and the state truly didn't know whether any requirement were met, then it could do so. However, that's not the case here. Something we know again from the draft denial where multiple water quality requirements were met and some weren't. And so knowing what specific requirements were at issue would at least give the applicant some information to form a new application.
Say we know that, so are you agreeing that the draft denial is technically incorporated into Maine's decision? You said we know that from the draft denial.
No, Your Honor. What we know from.
We don't. It's not
Well,
incorporated.
I don't agree it was incorporated because it was simply referenced in a footnote as a background fact.
Then we don't know that for purposes of Maine's decision here?
We know that the state could take an earlier, less comprehensive version of the same relicensing proposal and go point by point and identify which requirements were met and which were not. So there's no reason it could not have done the same here.
Is that required by 3? Just by Romanet 3? You haven't challenged the compliance with Romanet 3. Right.
We do challenge the compliance with 3 as well. The state said that it would benefit from the conclusion of the federal processes. That's not the same as identifying specific data and information that Brookfield should provide to assure that its discharge will comply from this project will comply with its state requirements.
I thought we were fighting about the word "and," which wouldn't matter if you were challenging Romanet 3.
Yeah, I think that the denial plainly doesn't include the information required by 1 and 2 on its face. The easiest way to overturn the decision of FERC is to decide that "and" means "and 1 and 2 aren't there. We also think that FERC's decision is unsupported by evidence in the record that 3 is satisfied.
Any other questions? Thank you very much.
Thank you.
Hear from.
Good morning, Your Honors. Angela Gao for the Commission. I'd like to pick up on a question that Judge Millett asked first, which is, if this regulation says will not comply, how can a state that doesn't have enough information to make a determination show that the project will not comply or identify which requirements that it will not comply with? That's exactly on the point. It doesn't make sense to read this regulation in the way that Brookfield does in the context of this regulation and what a state must do when it makes a certification decision. It's consistent with also how the EPA itself reads this regulation. As we discuss on pages 36 through 37 of our brief, EPA can serve as the certifying authority for waters that are not subject to any state's authority. And in that role, EPA has to follow the same regulations that states do, including 121.7E. And when EPA issues denials due to insufficient information, it only makes the findings required by subsection 3 and not those in 1 and 2. And it explains that the missing information needed to assure compliance under subsection 3 is also necessary to identify which water quality requirements will not be met and explain why that is.
The regulation doesn't make a whole lot of sense. I mean, you have to do one of two creative, you have to impose one of two creative readings on it, as I see it. You either have to do what you all would like to do, which is say that something in the form of one, two, and three means 1 and 2 or 3, which is pretty weird, right? Or you have to read will not comply to mean hasn't been proven to comply, which is also a little weird, but am I thinking about the choice the right way? And why is your spin on this less implausible than the other one?
I generally agree that it is a choice between those two readings that you've put forth. And I would say our position is more plausible because it's also supported by the text, the syntax, in the context of the regulation, as well as the statutory purpose of Section 401 and its waiver provision.
It's also, I mean, I guess the problem with will not comply is that Romanet 3 uses the exact language that they omitted in 1 and 2. It uses that they assure that the discharge will comply. Does that reverse burden things? So not only would we have to read will not comply to mean what Romanet 3 says, we'd have to defy that they know how to say it when they want it. I mean, it seems to have been a deliberate choice. So it's really even harder to say that will not comply means you haven't assured that the discharge will comply.
I agree with that, Your Honor. And I'd also point out that whereas, subsections 1 and 2, they reference each other. Romanet 2, it says will not comply with the identified water quality requirements. And those were identified in subsection 1. But in contrast, if you look at Romanet 3, it says will not comply with water quality requirements. And it refers there to the requirements in the general sense and not to any specific water quality requirements that Romanets 1 and 2 would require. Also, I'd point out to your point, Judge Katsas, that the syntax here supports the reading of this regulation to address two separate lists of criteria. Subsection 3 is set apart from the others by its own conditional clause. It says, if the denial is due to insufficient information, the denial must describe. And that, indicates that it refers to a different type of denial than what came before it. Also, it's drafted subsection 3 as a complete sentence that stands on its own and can be fully understood by itself, unlike Romanets 1 and 2, which are both dependent clauses.
Fragments, which are sentence fragments.
Mm-hmm.
Oh, sorry.
Which are sentence fragments.
Yes.
Yeah, I got it.
Correct. Turning to the context, it simply doesn't make sense to require the findings in 1 and 2 when a state doesn't have enough information to make those findings. And as Your Honors have honed in on, the key language here is will not comply from Romanets 1 and 2. The regulation, as we understand it, only requires identifying the standards with which the project will not comply and not those that it might not comply with. To conclude otherwise would require the state to make two conflicting findings. It has to conclude that the project will not comply with requirements under subsections 1 and 2, while simultaneously concluding that it lacks enough information to draw that conclusion in the first place.
But the Clean Water Act, as its general premise, says meet all 3 requirements. So by us just focusing on 3, just give me your general thoughts about a remand to require that there be specific information as to why will not comply with 1 and Romanets 1 and 2.
Well, I think if the court were to remand this to allow further explanation on points 1 and 2, I think Judge Katz's point that this is essentially then a pointless exercise of listing every plausible water quality requirement that the state has and simply saying, well, we didn't have enough time or information to evaluate the substance of your proposal, and therefore we can't reach a substantive determination. If the point of this regulation is, as Brookfield says, to provide the applicant with notice of what it must do, what information has it been provided if we did that to simply list out requirements and say that there was not enough information to make that determination.
You mentioned sufficient time. I know it's not a FERC regulation, so, but does FERC have a view or experience with understanding when there's a new submission just a couple weeks before, 3 weeks before the deadline here? And it's, for our purposes, deemed to be material and significant changes. Does that restart the clock? I'm not even sure which submission we're acting on, or FERC was acting on, or that they're talking about here. It's very confusing. But if it restarted the clock, then all of this is sort of a pointless exercise, because who cares if they waived their ability to act on a moot proposal or just supplanted or replaced proposal.
My understanding is that there's no automatic way that the clock resets, even when there's a very late stage and material modification to the application. But the case law from this court and others confirmed that what Maine did here is exactly appropriate for the circumstances. It issues a denial without prejudice that's not on the merits and says you're free to resubmit your application when you have the information that we need to make a merits determination. And that's in, for example, Turlock, where this court recognized that when environmental review is still ongoing, as it is here, a state that denies without prejudice because it doesn't yet have the information that it needs necessarily acts within the meaning of Section 401 and doesn't trigger waiver.
And doesn't have sufficient information can be a product both of insufficient time and obviously content of submission. Insufficient time can itself be a reason they as yet have insufficient information.
That's my understanding of what insufficient information would encompass. And I believe—
Maine said it can mean that.
Yes, correct. I'd also like to address a question from Judge Childs. I believe you asked, is it just information from these federal processes that the state needed, or also was there information that Brookfield needed to provide? And my understanding that it's both. It's not just the biological opinion and environmental impact statement, but also additional details about Brookfield's proposal that the state needed to make its determination. It's worth noting that after Brookfield supplemented in September, both the Commission and the Fisheries Service needed to request additional information from Brookfield to fill in the details of their supplemental filings. And one example of that is on JA 304 through 308.
Can you say something about the— so after Maine issued its decision and then Brookfield sought FERC's review of that decision, there's no indication that Maine participated in that proceeding. Is that right? Is that how they normally work? Maine doesn't seem to have been a party to the proceeding before FERC, or I don't see them. Usually, FERC always describes who argued what, and unless I'm missing it, did Maine participate, or
So
do they have a chance, or is this sort of you take the order and it just goes to FERC and the challenging party deal with it?
I believe Maine didn't participate in the sense of that it filed some sort of, rehearing request to the notice that the commission issued, confirming that its denial complies with the requirements of 121(7)(e). But it did submit in December of 2023 the copy of the draft denial, and in the cover letter transmitting the 2021 draft denial, explained why it believed its denial met the requirements of 121(7)(e).
Okay.
But I do want to also make this point that you touched on a point that this entire process is kind of unusual. Before the 2020 rule, the commission didn't have this formal role in verifying the content of a state's denial or certification decision. So this is all sort of new territory for the commission as well as to, what do we need to include in the notice? And then how do we interpret this regulation as to what needs to be within the decision?
I'm just trying to figure out because Brookfield argues that if it's right, as to its reading of the regulation and the content of Maine's order, which really doesn't, it says here's our draft, or FERC said it said here's our draft denial, and that would meet 1 and 2. But for the most part, there's if their position is that they didn't comply with 1 and 2, which is at least a difficult decision, that the consequence is waiver of their ability to act at all on this project, other than informal input in the federal system, or maybe filing a brief with FERC at some point. But they've lost this sort of distinct statutory role. And I'm just trying to figure out where, my assumption, I guess they'll tell me if I'm wrong, is that given both the text of the statute and our decision in Turlock, that Maine would have some arguments as to whether that should be the consequence, whether to the extent the regulation provides that consequence, it's consistent with the statutory scheme, either generally or particularly as applied in this situation when a whole new material and significant submission is submitted at the last minute that it doesn't have time to review. But it sounds like when they went to FERC to sort of see if they check the boxes on the regulation, the state doesn't show up as a party there. They sort of turn in their record of decision, maybe. Is there any point in the process when that argument would be made? When agency or courts would be able to assess that question? We don't really have briefing on that remedial question here, which seems to me, as you said, pointing out Turlock. And then the oddities of this case with a material and significant change just a few weeks before the deadline. A substantial question that I assume Maine would want to contest.
I can't speak to that. I don't know for certain whether there is some sort of formal way that a state could, submit briefing on their position as to whether their denial was sufficient. But
or what the remedy should be.
Or if the remedy should be waiver. But
or remand to explain yourself better, like we often do it.
Yes, I'm not aware of a case specifically in which a state certification decision has been remanded back to the state for additional explanation. But I don't think that the regulation would
if we were to agree with Brookfield, would we still then remand to FERC to address appropriate remedy? Or does that just get decided here?
If this case were remanded to the commission could, if
Brookfield, on the grounds that Brookfield was right, obviously, if we
Right.
remand, if we agreed with FERC. But
the commission could provide further explanation as to why the findings in 1 and 2 are met. And
not what the appropriate remedy should be.
the appropriate remedy, I'm not certain, Your Honor. I believe that if, the finding on remand is that the subsections 1 and 2 aren't met, then in our interpretation of the regulation is incorrect, then the consequence would be waiver.
Well, only if that's just a regulatory, that's in the regulation. There's nothing in the statute that says waiver in this context because the statute isn't clear as to when new submissions count and restart the clock. It just says you have to act. All the statutes say you have to act upon it. And take it the Maine's position, and Turlock said, you have acted upon it. And
Yes.
So I'm just trying to figure out procedurally where a dispute about what the consequence, if they were to be found to violate, would be sorted out. And would they need to raise that before FERC first?
I'm not certain, Your Honor. I apologize.
Okay. Any other questions? All right, thank you very much.
Good morning, and may it please the court, Robert Martin.
I think it's actually afternoon.
Is it
My
afternoon?
clock says noon.
We're very close, right on the cusp. Good morning or good afternoon. May it please the court, Robert Martin, Assistant Attorney General on behalf of the state of Maine. This case has serious implications for Maine. At risk here is a waiver of Maine's authority to impose mandatory conditions in a decades-long license to protect state water quality. Today, as Brookfield's FERC license is continually renewed on an annual basis, Brookfield is free to submit a new application for water quality certification to the department, giving the department the opportunity it's entitled to have under the Clean Water Act to evaluate its 11th hour submission from Brookfield on the last application, and having the benefit of the critical information from federal agencies that's now becoming available.
Brookfield also indicates that this Romanet 3, when you have the broad term of insufficient information, could just lead to delays by the state as well, particularly when you don't give the reason for indicating that it doesn't comply with any regulation.
Well, we think here the delay concern is minimal. In its denial without prejudice, the state didn't just identify some information, vague information that's coming available at some point in time in the future. It identified specific federal information that was absolutely and undisputably relevant to Brookfield's application, that it knew from representations from FERC and the Fisheries Service that would be coming available imminently. So there was no issue with delay here.
Particular provision on a case-by-case basis.
That's right. That's right, Your Honor.
Have they made, they can answer if you can't, but have they, maybe they would have made them to you. Have they made more changes that you're aware of now that there is a biological opinion and at least a draft EIS out?
If those changes happen, they would have been happening on the FERC docket, not before the state agency. They currently have no application pending before the state certifying agency, so I'm not aware if they've submitted updates to FERC in that sense.
Did the denial orders rest more on Maine's being put in an impossible position with this last minute supplement, or more on just Maine's view, like, gosh, it would be nice if we could see the biological opinion and all the forthcoming?
Your Honor, I think those are equally important grounds, and standing alone, if you
Rest
take
on both?
Yeah, if you take the federal forthcoming information out of the situation and you just have the sort of 11th hour document dump on the department, that would have been a standalone grounds. If you take that out and you just look at the forthcoming federal information that's relevant and specific to concerns that the department had about the pending water quality application, that's a standalone ground as well.
But we don't have to decide whether either of those would be sufficient because they were both relied on here, is your position in this case?
That's correct, Your Honor, although
If one can imagine the latter situation is one where the regulation really was trying to get the states going here and light a fire.
Yeah, the document dump one is more concerning to me.
That's right, Your Honor. And while that wasn't
in the context of, like, these reviews are always ongoing, there's always more you might like to assess.
Sure. And while that wasn't the exact issue that was addressed in this court's Turlock case, that was about forthcoming environmental reviews, the court did acknowledge the potential, slippery slope of always relying on federal information. We agree that these can be fluid processes, but here, the likelihood of the state kicking the can down the road on this was minimal, given that we knew, again, the specific timeline, the specific information, and its relevancy to the application.
But if they had made this September submission, what you all call the late stage submission, if that had been made in, 6 or 8 months before, and so really all you wanted, and you'd been able to evaluate it, but all you wanted was, after you, Alphonse, we'll keep waiting for the government to go, federal government to go first, you really would be in a weaker position, at least under this regulation, because that seems to be exactly what, it wants to say. You are a state, you have your independent program, your independent interests. That's what your role is about. And you need to let us know what the state interests are. The feds can figure out what their interests are. but you all need to keep marching and not keep waiting for someone else to go through the door first.
That's true that it is the state's authority that's at issue in this case, but this is somewhat of a unique and specific position that we find ourselves in, where the federal agencies are looking exactly at the same thing the state wants to be looking at as well, which is—
You're looking under state law, they're looking under federal law, and you are the expert on state law.
That's right. We do have expertise in state law. Some of our agencies do. But also, I mean, the state, it's well within its discretion to make a decision that it can withstand scrutiny in court. And, the state didn't know what this forthcoming information is going to say, and it may be helpful or it may be hurtful to the court's or the state's case. And in this case, it made the decision to wait on those, knowing that it was going to have specific consequences for the fish passage issue, which was the primary issue with Brookfield's application.
Do you have thoughts on, so it just struck me that the remedy claimed here, I get the regulation says if you don't comply with the regulation, every jot and tittle you waive, it counts as a statutory waiver. Is there, maybe Maine agrees with that reading of the regulation says that, I guess you'd have to agree with that whether that is lawful under the statute and under our Turlock decision. Is there a place where and when, maybe Maine thinks that's fine, that is a consequence, and then I'll be quiet. But if that's something Maine would want to contest, certainly on the case, at least in the situation when you have a last minute material and significant submission, where and when would you be able to raise that issue?
Sure. So two points, Your Honor. One relates to what is allowed by the statute when you look at this particular rule. Obviously, this rule has been replaced by a new rule. In full candor, the state of Maine participated with many other states challenging the validity of the 2020 rule and this provision in particular. That's not at issue in this case. Again, the 2020 rule has been replaced. It was dismissed without prejudice to renew challenges should it be revived in the future in the Northern District of California. So we did challenge the consistency between—
You're in an actual application of that regulation. No one seems to dispute
Sure.
that regulation governs at least the submission. I'm not sure, whichever the submission is that's before us, that submission. And so if they're right, the regulation prescribes waiver. And I'm trying to figure out, I don't think there's much ambiguity to the regulations consequence, but given the text and case law of the statute itself, at least in this circuit, just this question arose to me whether in fact that's a remedy that FERC could lawfully, I guess we remand for them to apply it.
to make a waiver determination.
You could seek review of that on the grounds that the waiver is beyond regulatory authority.
Well,
Is that the right process?
assuming, again, this is,
I don't want to assume that. but-
assuming that the court agreed with all of Brookfield's interpretations, what the regulation prescribes in that situation is a waiver of state authority. And that could be a remand to FERC to make that sort of determination from an order from this court. What I would
challenge
be
that
concerned,
remedy.
we may renew challenges at that point in time on
Well, just to the remedy.
excuse me,
Well,
to
I don't know,
the
maybe-
remedy.
I guess maybe you could to the whole regulation. You're right at that point. Okay.
Well, yeah, to the whole regulation. I think what remedy we would have serious concerns about would be in some iteration, it going to FERC and then coming back to the state. As has been discussed at length here, there is a regulatory or statutory deadline for the state to act under the Clean Water Act, and that's 1 year. And I would be concerned that any remand that finds its way back to the state would somehow bring up concerns that maybe the state, it's well beyond the state's time to act on this
But if we aren't sending
application.
it back to the state, if it goes back to FERC and we say, and means and. So figure out whether this complies with the regulation under that reading. And they look at it and they say, and you all would, I guess, have your arguments, but if FERC were then to say, yeah, it violates the regulation, your authority is hereby waived, your position is you could then come to this court to challenge that decision because you have a laundry list of objections to the regulation.
Sure.
One of which would be that waiver remedy is appropriate.
If it went back to FERC for a waiver determination ordered from this court, we'd have to look specifically into the law at that point. But I think that's a remedy that we would consider is whether the appealability of a new FERC order that would waive
Well, it'd
Maine's
certainly
authority.
be reviewable, and then the question is whether imposing waiver as a regulatory matter was within EPA's statutory authority, given how the statute talks about what acts are required and we addressed in Turlock, and that was met here.
Right. I think you're correct that characterization is correct. And again, for all the reasons my FERC colleague mentioned, we don't think the court should do that here.
But getting back to the waiver process generally, if you were to review the application and you felt like you had enough information to act on it, however, you still wanted the biological opinion or the EIS statement, how does that process work with respect to informing Brookfield, but yet is it approved potentially on the condition of those other things?
So under the Clean Water Act, there are certain actions that the state can take on a water quality certification application, all of which constitute an act within its 1-year deadline to avoid waiver. It can approve an application, it can approve with conditions, it can deny an application, or it could deny without prejudice. And it took the last choice here, which was to deny without prejudice, waiting for more information. To approve with conditions here wouldn't make sense because you need to know what those the agency would need the information before it to make a decision about what conditions might attach to that application. It couldn't include conditions in an application based on information that doesn't exist
You
yet.
kept referring to 11th hour dump, essentially. So is that the rationale or reason for why insufficient? Because you don't have enough time, or are you looking at it substantively and believe there's something?
Yeah, that's a good question, Your Honor. So we think that the insufficient time is the same as is essentially tantamount to insufficient information. If you don't have enough time to digest the information, then you might as well not have it. So that's the bucket that we put the last minute.
You say they're the
documents.
same, but then why not at least state that as your rationale? Because to me, time and substance is two different things.
I mean, I think the state did in its denial without prejudice say it doesn't have enough time to process this information. And just as a matter of process before the state agency, when they get critical information on an application, they reach out to their expert agencies, they reach out to stakeholders to let them know they've received updates, and they want to hear what folks have to say about this sort of thing so they can act on the best available information.
But if you say that it's based on insufficient time to process, then you don't have to go then into these other portions of the regulation that state what would be needed, et cetera.
Let me pull up. I think insufficient. I'm not sure if we said the word insufficient time in the denial without prejudice, but
We have yet to be late stage filing has yet to be analyzed.
right. So I think that can be read as insufficient time. Thank you, Your Honor, for that to process the information.
But my point is that you wouldn't then need to say what was needed because you're using insufficient time as your basis.
I mean, that you're right, Your Honor, that may have been a way that the state could have framed its denial. But again, in the interest of transparency, it wanted to let, the public and the applicant know what was happening.
They had, let's just assume their September submission, what you all call the late stage one, had been filed in sufficient time from Maine's perspective to analyze it. And you said, it looks great to us. We're signing off on it. And then, this is just a process question. And then 3 or 6 months later, a biological opinion comes out and it says, this is disastrous for salmon. Maine doesn't understand how this technology works. Here's why it's disastrous for salmon. Is Maine's role done? Or if they have to completely change what they're doing to address a biological opinion, does it then come back to Maine again to get approved? Or is it Maine's out and then you just have input maybe with the feds or something, but your job is done?
Well, we think the state's role in the federal permitting process under the Clean Water Act is clear. So Maine would have the authority there to impose conditions based on what it thought would adequately meet state water quality standards. I'm not sure if that means, and maybe this is really the crux of your question, if the federal agencies want to go further, what the state would do then. It seems like that would be an issue for, for
Your role, at least, your formal role, certification role would be done with. And then
I think that's right. If the federal standards wanted to be more stringent than state water quality standards, I don't think that's something the state would have an issue with.
Okay. Well, some states would.
State of Maine.
Any other questions? All right. Thank you very much.
Thank you, Your Honors.
Mr. Warner, we'll give you 3 minutes.
Thank you, Your Honor. I should be clear to start that Brookfield has been consistent all along that this quote late stage submission was consistent with its broader relicensing proposal and was immaterial when I was attempting to accept for the sake of argument this materiality issue, but that's certainly not something
You
Brookfield
said you could have
ready to
challenged it. You
concede.
haven't challenged it. You were accepting for purposes of this case that it was material and significant. That's what you told us. Was that inaccurate?
No, excuse me, Your Honor. I was accepting for the purposes of an exchange with you that my point was
Dropped
that
your challenges in state court to their decision. So.
you're correct, though that challenge was unrelated to the materiality
That
of
was
the
your
late
choice.
stage submission. I guess my point here is that setting aside the issue of the late stage submission, the state had an application for water quality certification, and under the Clean Water Act, it has to act on that application within a year. There's nothing in the Clean Water Act that says unless an applicant provides a supplement to the state or updates the state on its ongoing consultations with federal agencies, the state just has to act on that application. Now, presumably, if Brookfield or any other applicant wanted to amend its proposal in a material way or withdraw its proposal or file a whole new proposal, it would withdraw the existing proposal rather than asking the state to go through the process of rejecting something that no longer, or acting on something that no longer mattered. Here, however, that is not what happened because Brookfield's relicensing proposal had been before the state for a year and Brookfield had no intention of withdrawing it, and had simply attempted to update the state on its ongoing consultations with the federal agencies. Again, something that's fairly routine. The state was obligated under the Clean Water Act to act on the application before it, however it viewed the supplement within that 1-year deadline. In terms of,
I just ask a quick question.
of course,
Now that at least the biological opinion is out, and I don't know if you've done anything in response to the draft EIS from FERC, have you all made more changes in your proposal in response to, obviously not submitted to Maine, but more changes?
no, Your Honor, the proposal is, Brookfield's proposal is the same. My understanding
As a September submission.
As the September submission, my understanding is that the FERC environmental impact statement, the draft last month would add a few additional minor measures.
But you haven't changed your submission from September.
That's correct, Your Honor. And so I guess I also wanted to just quickly speak to syntax here. The reason I started my portion of today off by emphasizing asking whether and means and is that there's only one way if you're dealing with syntax that and can mean and here. And it's if we read element 1 to be saying that when an applicant fails to meet its burden, this means the discharge will not comply. Our position is just that that's a perfectly sensible way to read the first element, the only way that allows and to carry its plain meaning, and the only way that's consistent with the intent of the EPA when drafting these rules as explained in the introduction to the rules.
Any questions? Thank you very much. The case
Thank you.
is submitted.
This honorable shall stand adjourned until Thursday, April 25th at 9:13.